Okay, looks like Anna has the YouTube on. Don't care for the soap in this building.
No, does it not come
My
off?
nails are all, and skin around my nails are all splitting.
Yeah. Yeah, sometimes it can be really harsh. So harsh water, harsh soap.
Good morning. We are already streaming on the YouTube. Is it
Morning.
looking like anybody has any procedural matters that we're going to need to discuss when we go on our record? Mr. Rossi,
Good morning, Madam Hearing Examiner.
good
Staff
morning,
is,
sir.
staff is hoping that we can call Dr. Zadalis at 9 a.m. tomorrow morning, first thing. Hopefully, we shouldn't have to take him too far out of order. He has childcare lined up for his still sick baby, and that time works great for him. So we're hoping we can do that.
All right, sir. Anything further?
No, ma'am.
No.
Thank you.
Thank you. Anyone else have any procedural issues that we're going to need to deal with when we go back on our record? Not hearing anything. Oh, Mr. Alvidres. Go ahead, sir.
Yes, Madam Hearing Examiner, are you able to hear me?
I am. Good morning.
Good morning. I was wondering when we'll take up the uh, any witness George issue.
We'll do that this morning.
Okay.
Okay.
Madam Hearing Center, not a procedural issue, just doing a mic check. Can you hear us?
I can.
Thank you.
Thank you.
Madam Hearing Examiner, same for me. I'm in a different room.
Yes, sir.
Thank you very much.
Thank you very much.
Good morning, Madam Hearing Examiner. This is Chris Walters, just doing a video and mic check.
Yes, sir. Good morning.
Good, nice to see you again. Thanks.
Madam Hearing Examiner,
Mr. Tomei?
as a procedural matter, I can inform you that we have a draft of the third bench request, a final draft that is being typed up. And so that should be available to be served on the parties within the next half hour or so, Madam Hearing Examiner.
Very well. Thank you, sir.
You're welcome.
Very well. Good morning. We have returned from our evening recess on Monday. Yesterday was a holiday, Veterans Day. Thank you to all the veterans. And we are returning for day 7 of our hearing in case number 24-00266 UT. This is in the matter of the joint application for approval to acquire New Mexico gas by Saturn Utilities Holdco. My name is Elizabeth Hurst. Along with me today is my co-hearing examiner, Patrick Schaefer, and our court reporter, Mr. Lee. If anyone needs anything to do with the transcript, they need to see Mr. Lee directly. Let's go ahead and get our appearances on the record pursuant to request, beginning with joint applicants, Mr. Alvidrez.
Good morning, Your Honor. Rick Alvidrez on behalf of the joint applicants, and with me today is also Dana Hardy and Will Dubois, who will be conducting the cross-examination of the first witness.
Thank you. Mr. Dome?
Yes, ma'am. Good morning, everyone, hearing examiners as well. Again, Tom Domi, Brian Haverly, and Juliana Hopper on behalf of the joint applicants Amera and New Mexico Gas Company. And also with us again is Nicole Strasser, General Counsel for New Mexico Gas Company.
Thank you. Mr. Gould?
Madam Hearing Examiner, this is Joseph Yar. I'll be doing the defending the witness, Your Honor. With me here is Peter Gould. We're here on behalf of New Mexico Affordable Reliable Energy Alliance.
Thank you, sir. Ms. Beatles? Ms. Lynch?
Good morning, hearing examiners Hurst and Schaefer, as well as the colleagues that are present. I am Kara Lynch, attorney for Coalition for Clean Affordable Energy and Prosperity Works, here with my colleague Charlie DeSalin, representing CCAE.
Good morning. Thank you. Mr. Freeman?
Good morning, everyone. Jelani Freeman appearing on behalf of the federal executive agencies.
Thank you. Ms. Nanasi?
Good morning, Hearing Examiner Hurst and Schaefer and colleagues. My name is Marielle Nanasi, and I am representing New Energy Economy.
Mr. Friedman?
Good morning, everyone.
My name's Ryan Freeman, and I'm representing staff today, and I'm here with my co-counsels, Nicholas Rossi and Katie Lang.
Thank you. And I'm going to try this. Mr. Uzaitis?
Good morning, hearing examiners and colleagues. My name is Anthony Uzaitis, and I'm here on behalf of the New Mexico Department of Justice.
Thank you. I'll keep practicing. Very well. I think we have our appearances on the record. When last we were on the record, Monday evening, there were some procedural questions with regard to the pending nature of NEE witness Sandberg's exhibits. to his testimony. And hearing examiner Schaefer and I heard argument from objections had been lodged by joint applicants plural, I believe on exhibits 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and I believe 22. Mr. Alvidrez, that comport with what you had, or were you also objecting to 21?
Madam Hearing Examiner, Mr. Dome took the lead on the objections to the exhibits to Mr. Sandberg's testimony. So if
Okay,
he may address.
Madam Hearing
Mr.
Examiner,
Dome?
Madam Hearing Examiner, we did not object to 22. I simply indicated that 22 is repetitive of number 4. So there's no objection to 22 or to 4. And as I reviewed my notes, Madam Hearing Examiner, I would like to withdraw the objection to number 8. That's a press release that I inadvertently threw into the list of things. That's not an article. That's a press release that was propounded by the company. So I withdraw the objection to number 8. And I did not object to numbers 20, 21, or 22.
Okay. I will begin with Mr. Sandberg's exhibit 3, which was an excerpt from the deposition of Mr. Bodier. I do not believe that was specifically objected. Well, did you object to 3, Mr. Dome?
No, I did not, ma'am.
Okay. The hearing examiners had a question about 3 and the use of an excerpt from a deposition. And we were told, I think, during argument that deposition excerpts had been utilized previously as exhibits. Upon review of the testimony, which sets forth the excerpt of the deposition, rules 703, 803, rules on hearsay, and the opportunity to cross-examine the witness on this point, I do not find this is an acceptable or an appropriate use of a deposition excerpt. I believe, again, Mr. Sandberg has in his testimony the actual information, and I do not believe that it is legally appropriate. And it is also potentially duplicative to include repetitive testimony as an exhibit. So CKS Exhibit 3 is not admitted.
Madam Hearing Examiner, for the record, I would like to object and say that it's also a statement by a party opponent, and for that reason, believe that it should be admitted as well. So I just wanted to make that 801 D3 objection.
And again, Ms. Nanasi, you actually cross-examined Mr. Boudier on that statement, correct?
Not on his words in the deposition,
Okay.
but on the topic, I did. And I also cross-examined Ms. Hutt as well, and I believe some other people did as well about the topic.
Okay, very well. I'm still gonna deny CKS 3. I believe you're calling it an admission of a party opponent. I believe that you had the opportunity to cross-examine him on this, and if you chose not to, that was your choice. So let's go on with regard to the articles or papers at CKS 7, 8, 9, and 10. Again, after reviewing the rules that allows experts and testimony generally, or not testimony generally, but rules regarding testimony generally, I am aware that that experts can rely on pamphlets, learned treatises to support their opinion. However, I believe that under the rule and the exception to hearsay, that the evidence can be relied on as an exception to the hearsay rule, and it can be the basis of or help formulate the basis of the opinion of the expert. I believe that Mr. Sandberg has relied, at least according to his testimony, on certain opinion that is contained in the those writings. It has influenced his opinion, and I believe he has stated such in his written testimony. Therefore, since he's been allowed to rely on on that potentially hearsay opinion, it is not necessary, nor do I believe in keeping with the rule that the actual document itself is appropriate to include as an exhibit. Therefore, I'm going to deny CKS 7, 8, 9, and 10. With regard to CKS 11, 12, 13, and 14. No, 13. 11, 12, 13. Those appear to be articles regarding events between private equity and potential impact on the healthcare system. Again, to whatever extent Mr. Sandberg relied in his written testimony on those, they will be given the appropriate weight, if any, with regard to whether they have relevance in this matter. However, there's been a foundation and a relevance objection with regard to healthcare topics as not being relevant to a gas acquisition case. And I do not believe that, again, for the reasons I've already stated, with regard to rules 703, 803, exceptions, and the fact that a hearsay document as an exhibit, as a basis for an opinion, especially in these three exhibits, they're not appropriate, and I'm going to deny 11, 12, and 13. Regarding CKS 14, again, another article or opinion paper on regulating mergers and acquisitions of electric companies. There's been an objection based on foundation and relevance. And I make the same finding. 14 is denied. With regard to the witness has given his opinion, and if he relied on that, then his testimony is what will be considered not an improper hearsay exhibit. 14 is denied. With regard to CKS 15, which were comments made in a Minnesota case on an acquisition case that the parties indicated the final order was not out. Again, there was a foundation and relevance objection made. And I also find that's an impermissible hearsay document from another proceeding somewhere else. that actually can't be or can't be examined and is again impermissible hearsay. So I deny CKS 15. Now, with regard to CKS 16, 17, 18, and 19, these all have to do, it's my understanding, with the El Paso Electric and certain actions that El Paso Electric has taken, primarily in Texas, I believe. I know that 18 and 19 are specifically Texas. El Paso Electric is not one of the interveners or parties to this case. I believe that the parties have requested that, or at least have purported exhibits with regard to the El Paso Electric acquisition case that took place here at this commission a few years ago. And then there were actually questions, I believe, on Monday of Mr. Sandberg regarding this particular area. Therefore, again, it's the witness's actual testimony that he can be cross-examined on that's coming from his own analysis that is important and probative. And I do not believe that exhibits 16, 17, 18, and 19 meet the standard under the hearsay rule to be included again as exhibits. Therefore, I'm denying 16, 17, 18, and 19. There was no objection to 20. CKS Exhibit 21 is another article and or paper entitled something to do with acquiring regulated natural gas assets. And for the same reasons, after reviewing the rules on evidence and looking at the exhibit and looking at the witness's testimony, I do not believe that this this out of state, out of proceeding document on its own should be admitted as an exhibit. I believe to the extent that the witness has testified that that something in this document may have influenced him, that's what's appropriate under the learned treatise exception to hearsay. It's the opinion. It's not that actual document. Therefore,
Madam Hearing Examiner, again,
hold on. CKS 21 is denied.
so just for the record, I want to point out that CKS 21 is a admission of a statement of a party opponent, and it's BCP's own sort of press release / article about the New Mexico Gas Company acquisition. And Mr.
Well,
Sandberg was cross-examined about, did testify. I withdraw was cross-examined about. I don't remember if he was or not, but he testified about the blueprint that is sort of the way, and I also cross-examined Mr. Baudier about the blueprint of BCP.
so you're saying it's the part of a foundation for Mr. Boudier's testimony also? Ms. Nanasi?
Could you ask that or state that again, please, Madam Hearing Examiner?
Right. So you're saying not only was he cross-examined, but it was part of the basis for the joint applicant's opinion too?
Well, I definitely asked Mr. Baudier many questions about BCP's quote blueprint unquote. And he testified extensively about that.
Okay.
Mr. Sandberg also testified about it in his written testimony. I'm not sure if he was asked questions, if Mr. Sandberg was asked questions about the blueprint.
Any response? Mr. Dome, you were okay with you were okay with 21, is that correct?
Yes, ma'am, I was. I did not object to 21 because it is a BCP doc itself, so I didn't have objection.
Okay.
And the same thing, Madam Examiner, for CKS 8, which you talked about earlier, but that is and I tried to indicate this morning that is an Amera press release. So I withdraw my objection to number 8 for essentially the same reason. That's a a document of the party. So 8, I think, should be allowed in, and 21, I do not have an objection to.
All right then. Based upon the representation of the parties, and considering the fact that the documents appear to be generated from the joint applicants themselves, I will revisit my ruling and allow CKS 8 and 21 to be admitted for whatever consideration that the commission would like to give them. Ms. Zanossi, do you have any response that CKS 22 and 4 are the same thing?
They are.
Can we just include one?
Yes.
Would you like to include the first one?
Yes.
If your witness references 22 in his testimony, will you change that to 4?
Yes.
Just so that we understand which exhibit he's referring to. Does that make sense?
Yes.
Okay. Very well. With those rulings, and subject to check, I'll still keep any exhibit 1 under advisement until you have put a conforming copy into the Dropbox.
Madam Hearing Examiner, I have a question.
Sure.
Do you want me to go back into his testimony and remove the citations to those exhibits and renumber the rest of them accordingly? Or how do you want me to do it? And do you want me to do
Let
it?
me think about that.
Okay.
I want it to be as clear, not as clear as mud, but yeah, let's think about the best way to do that. And obviously we want our record clear. You know, I don't want the citation removed to whatever document he cites to, but only that it's an exhibit.
I understand that. So I could renumber them accordingly and change it, or I could just remove the exhibits from the testimony and leave the rest as is, however you instruct.
Okay. Let me think about it. I want to try to be as efficient and clear as we need to be. Okay?
Yes, and I would
I'll get back
also-
to you.
Okay, thank you. Also, Madam Hearing Examiner, I would like to make then what is currently labeled as New Energy Economy Exhibit 1 with the testimony and the exhibits and offer of proof under 1.2.2.35M
Okay.
for the record. And so
Okay.
I can change this exhibit to read, New Energy Economy Offer of Proof, and then put into the record whatever you deem is appropriate for his testimony and New Energy Economy Exhibit number 1.
Well, what are you going to go ahead and make your offer of proof now?
The offer of proof is what is currently New Energy Economy Exhibit 1. Yes.
Okay, I'm confused. What?
For the commission and for appellate purposes, I want to make this document as is an offer of proof. I think that's my right under 1.2.2.35M. And I will also comport 100% with whatever your ruling is and change the document to be the one that you have accepted or will accept.
Okay. Okay, but your offer of proof is the exhibit prior to the rulings.
Correct. And I'll relabel that as New Energy Economy offer of proof.
Okay. Very well. Anything further?
No, not on this exhibit.
Okay,
Thank you.
thank you. Hearing Examiner Schaefer, did you have anything that you wanted to say with regard to these rulings?
Not at the moment, Madam Hearing Examiner.
Okay. I also wanted to, for the record, let the parties know that the two cases cited by Ms. Nanasi, Bearwald v. Flores, and Furstenberg versus Monrebo. I did in fact review those cases and others with regard to making my rulings. Okay. Additionally, we have the procedural issue of whether or not NEE Exhibit 2 Mr. George's pre-filed testimony comports with the ruling that was issued order granting in part and denying in part joint applicants' motion in limine to exclude the direct testimony of NEE witness George. Pursuant to this order issued on November 3rd, Ms. Nanasi, you indicated that you had changed the version of the testimony that you put into the Dropbox to comport with what you believed was the order. Is that correct?
Yes, Madam Hearing Examiner.
And joint applicant attorney, Mr. Alvidres, disputed that the testimony comported with the ruling. And so after that, you maintained that you believe that that this version did in fact comport Is that correct?
Yes,
Okay.
my understanding was that your ruling said that he couldn't be deemed a expert witness, but that he could rely on his firsthand knowledge and what he has learned and researched and knows from regulatory proceedings that he's been involved with BCP and Delta, specifically Delta Utilities.
Okay. Yeah, and just so the record's clear, um, uh, hearing examiner Schaefer and I did find that that Mr. George was not his testimony was not in the purview or met the standards to testify as an expert. We did not find that his qualifications and what he attempted to opine on as an expert, specifically, he's not qualified as an expert in New Mexico regulatory law or policy. Therefore, he couldn't testify as an expert witness. But we did find that he has offered testimony of other regulatory proceedings in which he participated with joint applicants or their affiliates that may be of some relevance. Therefore, we found that Mr. George could testify as a lay witness to other regulatory proceedings in which he participated with joint applicants or their affiliates. Therefore, specifically finding that his Exhibit B was stricken and that he could provide lay testimony as to his personal knowledge of regulatory proceedings in which he participated with joint applicants or its affiliates. And you believe that that's the revised version that you submitted, Ms. Nanasi?
Well, I will say that your order was silent about his firsthand knowledge of other situations, like, for instance, the complaints that he personally has received around Delta Utilities. You didn't make a finding either way, but because I took a broad view of what your ruling was, I left in the rest of the testimony, I took out essentially that specific exhibit that you said and relabeled the exhibits numerically. But then the rest is Mr. George's own understanding, research, investigations, experience with BCP's Delta Utilities.
Mr. Alvidrez?
Yes, Your Honor. As I think you and hearing examiner Schaefer recognized, the only thing that was excised from the proposed George testimony was the exhibit, as Ms. Nanasi indicated, and the reference to that exhibit in a footnote. Ms. Nanasi indicated that you didn't say anything about Mr. George's testimony had to be based on personal knowledge, but I would direct you to the second to last sentence in your order. It says, on page 4, Mr. George may provide lay testimony as to his personal knowledge of regulatory proceedings in which he participated with the joint applicants or its affiliates. And there's quite precious little in this testimony that had anything to do with Mr. George's personal involvement. It's limited to the New Orleans proceeding involving the Entergy entities that were acquired by the Delta Utility entities. It had nothing to do with, NWI, had nothing to do with any of the other claims that he makes. And he gives many, many opinions about New Mexico law and whether the BCP applicants are qualified to, acquire, which I think is clearly beyond the scope of what your ruling permits.
Ms. Nanasi, do you want to respond to the objection?
You're on mute.
Mr. George is an attorney since 2008. He's a utility expert for the last 6 years. He can read, and he read the 6 factors that apply in this matter and applied it to the information that he knows about and has learned about as a lawyer and as an advocate, a utility advocate in Louisiana, where BCP's Delta Utilities operates. And that's what he has done. Everything in there comes from his research, his personal knowledge. It says here that Mr. George may provide lay testimony as to his personal knowledge. And this information has come from that knowledge. So that's why I think it's relevant. He's the only witness who actually knows something about how Delta Utilities has run. And he also knows something about the only other utility that BCP had before Emera purchased it, which is the National Water Infrastructure. And there's lots of information about that. Do I think that that goes to the character and fitness of this potential buyer? I do. And I think it's relevant to you and to the commission.
Your Honor, may I respond?
Yes, sir. Go ahead.
Well, I don't think it sounds as though Ms. Nanasi hasn't given up on her argument that he is an expert. And what she's described is, the work that an expert would do, research and looking into things and drawing conclusions and inferences. But that's outside the scope of what a lay witness does. It doesn't say anywhere in his testimony that he investigated or did anything. On page 1 at line 16, 17 and 18, he basically says that, he reviewed the application and some of the discovery in this case. And if you, look at the exhibits that he relies on, it's, primarily things that were produced in discovery. So, it's a situation where he wasn't involved in any of the NWI case, according to his testimony. He wasn't involved in railworks. He wasn't involved in elevation. He wasn't involved in anything that in anything other than the proceeding before the City Council of New Orleans. And there are just a couple of references to that in his testimony. One has to do with a discovery dispute, and the other are some follow-up phone calls or claim complaints at the end of his testimony, about service quality issues.
Madam Hearing Examiner, I will just say that there are other people besides lawyers who do research, especially if you're a utility advocate. So, and a community activist. So I'll just say that for the record.
Mr. Nasi, this is Hearing Examiner Schaefer. We've ruled on this issue. Mr. George may not testify as an expert.
I understand that. Oh, sorry.
Okay. So that issue has been settled. The question that we're discussing at the moment is what shall or shall not, or what may or may not be included in his written direct testimony. And as Mr. Alvidrez quoted, he may testify to his, as the order stated, to his personal knowledge of regulatory proceedings in which he has participated. So is there anything else that is there anything unclear about that, or any further questions?
So for instance, is it your ruling that his receipt of calls from people regarding BCP Delta Utilities should, I mean, basically that means that his entire testimony should be struck, right? Except for like
Well,
3 or 4
that's
lines.
not, Ms. Nanasi, that's not my concern.
I'm
That's
just
not-
asking to try to clarify your ruling then, because I had a different understanding of what you ruled.
Reiterate it as was stated by Mr. Alvidrez. Mr. George may provide lay testimony as to his personal knowledge of regulatory proceedings in which he participated with the joint applicants or its affiliates. Examiner, is there anything else you'd like to add to this point?
Thank you, Hearing Examiner Schaefer. I thought the order was pretty clear too, about the limited scope as a lay witness that Mr. George could testify to. So to the extent, Ms. Nanasi, that any exhibit 2 doesn't comport with our order from November 3rd, it needs to be edited in such a way that it does comport, and when Mr. George testifies orally, he's going to be limited to what we said he could testify to in the order. Okay. So, the actual exhibit is still pending. But with that instruction, when Mr. George comes up, you'll be expected to have a copy that comports with the order to offer into evidence. All right. I believe then that concludes the outstanding procedural issues. I see Mr. DeSalen, you've raised your hand, sir.
Before
Yes, I
Mr.
have.
DeSalen speaks, I'm sorry, excuse me, Mr. DeSalen, I want to make the complete current New Energy Economy Exhibit 2, or actually the first one, to be another offer of proof. So that will be New Energy Economy Offer of Proof number 2. And then I will strike out 99% of Mr. George's testimony and have it uploaded in time for his direct oral.
All right, Mr. Nelson,
Thank you.
thank you. Mr. DeSaler?
Thank you, Madam Hearing Examiner. I just have a question regarding your rulings on the articles that were introduced by Ms. Manassi. We have, as some of our exhibits, articles as well, and I will be prepared to address the admissibility of those articles. But and there's some additional considerations, I think, that we haven't considered so far. And I was wondering if I should just wait until our witnesses are up and discuss it then, or raise them now. I just don't want to be in a position where it appears that I've waived arguments as to the admissibility of such records or such documents.
No, sir. I think the appropriate time for you to deal with potential challenges to what you offer as evidence is at the time you offer it.
That's what I thought. Thank you, Madam Hearing Examiner.
Thank you. All right. If we have nothing further procedurally, I believe if we go back in to our witness order, we are going to hear from NM area witness Mr. Walters. Mr. Yar?
Yes, Your Honor, that is correct.
Go ahead, sir.
With your permission, Your Honor, NM area calls Mr. Chris Walters to the stand.
Good morning, Mr. Walters again.
Good morning, Madam Hearing Examiner.
Mr. Lee, would you please swear the witness?
Mr. Walters, would you please raise your right hand? You solemnly swear the testimony you're about to give to the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Lee.
Go ahead, Mr. Yar.
Thank you, Madam Hearing Examiner. Mr. Walters, can you please state your full name for the record?
Yes. My name is Christopher C. Walters.
And by whom are you employed?
I'm employed by the firm Brubaker and Associates Incorporated as a principal of the firm.
And in what capacity are you testifying here today?
I am testifying on behalf of NM Area as an expert witness in regards to the application for the acquisition of New Mexico Gas Company by the BCP applicants.
Mr. Walters, do you have before you what has been marked as NM Area Exhibit 1?
Yes, I do.
Can you tell us what that is?
Sure. It is the corrected direct testimony of Christopher C. Walters that was filed on, I believe, October 28th, 2025.
And that was to correct and update certain issues raised in your original testimony that was filed on September 26th. Is that correct?
Correct. It was to make corrections to my originally filed direct.
Okay.
As of the September, that was filed on September 26th. So as of September 26th.
Okay. And those corrections became apparent. Why, Mr. Walters?
I realized them in my preparation for my deposition earlier in the month of October.
Okay. Let's take a moment and walk the court through those corrections. You have the document in front of you. Are you looking at it, sir?
Yes, I do, and yes, I am.
Okay. So I guess the first correction would be on the affidavit. Your affidavit, is that correct, sir?
Yes,
And that's just to update the date, correct?
correct.
On the next page, which is the table of contents, do you have some corrections there?
Yes, the first correction is just to update the page number of section 7. It updates from page 27 to 28. Similarly, for section 8, that is to update the beginning page number from 34 to 35. Similarly, updating the page numbers for section 9. Those page numbers update from page 40 to beginning on page 41. And finally, on section 10, those page numbers are updated to begin on page 44 instead of 43.
The next correction, I believe, is on page 7. Is that correct, Mr. Walters?
That is correct.
And what are the corrections there?
Specifically in footnote 11 at the bottom of the page, I update the reference from a single page to pages and include pages 47 and 48.
I believe the next correction's on page 11. Is that correct, Mr. Walters?
It is.
And what is the correction there?
In footnote 20, I, for clarity, added that it was provided, the cited document was provided in NM area CCW1, which was attached to my testimony.
The next correction that I see, Mr. Walters, is on page 13. Is that correct?
That is correct.
Can you tell the court what the what those corrections are?
Sure. Similar to the previous correction, it was to simply add provided in NM area CCW1. And that's in footnote 22 at the bottom of the page.
Thank you, sir. Moving along, I believe the next correction's on page 14. Is that correct?
It is.
Tell us what those corrections are.
The same correction simply adds provided in NM area CCW1 to the footnote 24.
Moving to the next correction, I believe, is that on page 15, sir?
Correct.
And what does that change?
The exact same correction we've just discussed. I added, for clarification, provided in NM area CCW1. And that's to footnote 25.
Thank you, sir. The next correction. No, we're not there. Page 16.
There are two corrections to the footnotes on this page. First, in footnote 27, it's the same corrections we've just discussed, adding provided in NM area CCW1 to footnote 27. Following on footnote 28, I strike through and add 5-5, comma, and so now the footnote reads joint applicants' responses to NM area interrogatories 5-4, 5-5, and 5-6 provided in NM area CCW1.
Moving to page 17, sir, are there corrections on that page?
Updating the two footnotes at the bottom of the page, strike page 34, insert 39. strike line 24, add 5. Strike page 35, add page 40. Strike line 5, add line 9. Moving on to footnote 30. Strike page number 35, add page number 40. Strike line reference to lines 17 through 25 to add lines 16 through 25.
Page 18, are there any changes?
Corrections to the footnotes. First, footnote 31. Strike page 22, add page 26. Strike line 25, add line 10. Through page, strike 23, add page 27. And strike line 9, add line 10. Moving on to footnote 32 on that same page. Strike page 23, lines 14 through 20 to now reflect page 27, line 11 through page 28, line 5.
On page 19, are there any changes, sir?
Updating the footnote 33 at the bottom of the page. Strike page 35, add page 39. Strike line 43, add line 14. Strike page 36, add page 40. Strike line 8, add line 9.
The next change I see, Mr. Walters, is on page 26. Is that correct?
Yes.
Can you tell us what those changes are, please?
Sure. On line 3, I'm striking the reference to 43 billion and updating that to US 30 billion. And then I add footnote 48 in relation to that for clarification. And then the new footnote 48 reads as follows. Emera reported CAD, or stands for Canadian dollars, 43 billion in assets as of fiscal year 2024, period. S&P Capital IQ provides a USD or US dollar converted value of approximately US 30 billion.
These changes were, again, I'm sorry. Mr.
There's
Walters.
a couple more corrections on this page, as
Sorry.
indicated on line 6. The reference to 5% is updated to 7%. And that's just to reflect the updated, the relative portion of the updated values. And then similarly on line 13 of that page, it's just another correction that was made on line 3 where we update 43 billion to US 30 billion.
And just to clarify, these corrections made on page 26 were a result of what?
I realized in preparation for my deposition that the initial ballot values that I looked at were reported in Canadian dollars, and I had errantly compared that value to the $2 billion commitment of the BCP funds. The correct comparison would have been the $30 billion in assets in US dollars as reported by S&P Capital IQ. It was also previously
S&P.
I'm sorry, sir. S&P Capital IQ.
Thank you.
Certainly.
Thank you, sir. Moving along, I see that the next correction is on page 30. Is that correct, sir?
This is an additional correction we were going to make.
Okay.
On page 30. If you want me to take care of that now, I can.
Yes, please.
Make sure it's not in the corrected. It's not in his.
I can hear you, Peter.
As my co-counsel is
One
trying to help.
witness, one
Right.
attorney per witness.
Understood, Your Honor. As a point of clarification, this particular change is not in the corrected version, the red line corrected version. And what we're trying to do here, Your Honor, is just notify the parties and Your Honor that this correction is a result of what, Mr. Walters?
It was just a review of my testimony and documents in preparation for this hearing today.
Can you tell us what that change is, sir?
Sure. At the top of the page, starting on line 1, at beginning with the word response through the word applicants on line 2, I will replace or strike response to NM area interrogatories 5-10 and 5-11, comma, the joint applicants. And I will replace that with in Mr. Tuminello's deposition at pages 24 to 25, comma, he. And then that would also need to be reflected in the footnote 58. So strike what is indicated in footnote 58 and replace with Tuminello deposition at pages 24 to 25.
Thank you, sir. The next change I see is on page 33. Is that correct, sir?
Yes.
Can you tell us what those changes are?
Would you like for me to read into the record, skipping over the strikes as it should be read? Or how would you like for me to approach that?
Why don't you just indicate what's stricken and then clarify the record with what the testimony states?
Okay. Beginning on page 33, starting on line 13, at the word testimony, through line 18, where it reads 48.7, that will be struck. Then beginning on line 18 at the word, beginning with the word at, or the phrase at the time, that will strike, carrying through line 19, through hypothetical $40 million increase. Again on line 19, strike beginning at with the word future rate. All of line 20, carrying through page 34, line 3. So all the way through line 3, where it reads, in fact, Mr. Shell admits that, quote, this, that will be struck. Then line 4, what will be struck is delay can be valued, comma, albeit not. Again on line 6, beginning with the phrase the degree, will be struck all the way through line 8, through the first word hour. Again on line 8, beginning with the word or the phrase commission approved, through line 8, and the word considering will also be struck. Line 9, the word and will be struck after effect on line 10. of providing will be struck. On line 13, the quotation and I guess footnote 68 would be struck. And then also the footnote 66 at the bottom of page 34 would also be struck. So that's all of the components that are struck that we are proposing to strike from the testimony. And if you would like, I would then read how it should be reflected and read from the testimony with the corrections, if you would like.
Please.
So the answer beginning on page 33, line 13, carried through page 35, line 3, shall read as follows. Not necessarily. Mr. Shell's estimate of the 30 million to 40 million in customer savings from the 1-year rate case deferral appears incomplete for at least 2 reasons. First, his testimony indicates that the estimate is based on a comparison to NMGC's last rate case and the time elapsed since those rates went into effect, coupled with NMGC's ongoing capital spending and cost trends. However, because the joint applicants have committed to delay a rate case filing by at least 9 months, additional inflation will continue to build into NMGC's cost of service before new rates are implemented. Those higher costs will ultimately be reflected in the next rate filing, thereby eroding some or all of the near-term savings Mr. Shell projects. Second, his estimate appears to reflect only NMGC's current cost and does not account for the joint applicant's stated intent to seek regulatory asset treatment with a cost of capital carrying charge for the projected 32.5 million to 44.9 million in transition costs related to IT shared services. When the effects of additional inflation and recovery of these transition costs are considered, the net benefit to customers could be materially smaller than the 30 million to 40 million cited by Mr. Shell, if not eliminated entirely. And that's the extent of the insertions. And just to be clear, these were prefaced with and presented to the Joint Applicants Council at the outset of my deposition earlier in October and discussed at that time. And it is related as at the time of my direct testimony. It's just a simple correction, albeit a long correction to my originally filed direct from September.
Then the next corrections on page 37. Is that Mike? No, that's not right. Sorry. Page 38. Is that correct?
Correct.
And what's that change?
It'll be in footnote 70. Striking beginning at where it says 47. So strike 47 lines 4 to 18. Replace with 52 lines 7 through. Strike 48 lines. Replace with 53 line 16. Semicolon page 63 line 15 through page 66 line 25, semicolon page 84 line 3, and then strike through 14, insert through page 94 line 17.
Next change is on page 39. Is that correct, sir?
Correct.
Can you tell us what those corrections are?
Yes, similar. We're going to be updating We're correcting footnote 71. So strike where beginning at 55 where it says 55 comma lines. Replace that with, I'm sorry, following that it says through 91. And then inserting line 15 through page, and then strike 59 lines 15 through, inserting 66 comma line. So that footnote will read as follows: id dot page 63 line 15 through page 66 comma line 25 provided in NM area CCW 3.
And then the last correction that I see, sir, can you confirm that on the first page and throughout the entire document, the word corrected is added to the beginning of your title, which is corrected direct testimony and exhibits of Christopher C. Walters. Is that correct?
Yes, it is added to the title of the cover page to read corrected. And I would also note that it is inserted on the header of each page throughout the entire document.
Just as a point of clarification, sir, your corrected direct testimony was filed on October 28th, 2025. Is that correct, sir?
Yes, it was.
And the purpose of this testimony was to respond to the joint applicant's July 3rd revised direct testimony. Is that correct?
That is correct.
Your Honor, Will Dubois.
Mr. Dubois, is there a reason you're interrupting this?
There is, Your Honor. It is, I think, something I have not seen to get into asking the witness what the purpose of their testimony is in the process of getting, establishing the exhibit to be moved in. I think we've already been.
I'm sorry, whoever is whispering, I cannot hear Mr. Dubois. The exhibit to be admitted.
I don't think it's part of establishing the foundation for moving it in. In the process of some of the lengthy reading of corrections, we've already basically been getting into live direct examination. So I would object to asking the witness the purpose of their testimony as part of live examination right now.
Mr. Yar?
I think we're just clarifying the record, Your Honor. That's all. We're not intending to do anything other than to make sure it's clear that these changes are reflected to indicate that this testimony is responding to a certain, it is in response to the applicants. That's all.
Might be speedier next time if you try to get the parties to stipulate to your corrections rather than taking up the hearing time.
Point taken, well taken, Your Honor.
You know, just move on, sir.
Will do so, Your Honor. With that, Mr. Walters, if I were to ask you the same questions that are contained in this document, would your answers be the same?
Yes, they would.
Is the information in your document and the exhibits true and accurate as you understand them to be?
Yes.
Madam Hearing Examiner, I'd like to move into the record, NM Area Exhibit 1.
Mr. Walters, did you prepare the exhibits that were attached to your testimony? Or were they prepared under your direction and control?
Yes, they were prepared under my direction and control.
Any objection to what's been identified as NM Area Exhibit 1, the corrected direct testimony of Mr. Walters as he has affirmed here?
Your Honor, Will Dubois.
Mr. Dubois.
I'd note that the exhibits 2 and 3, NM area CCW-2 and NM area CCW/3 are both deposition transcript excerpts. And in particular, CCW-3 includes a number of Q&As where objections were preserved. In light of the earlier ruling on the use of deposition transcript as exhibits, I would make an objection for the same reasons.
Those reasons being?
Well, I'll add the additional one on 3 that this would be a way of getting in Q&As from a deposition where there were objections that were preserved. In addition, I don't think they've established a basis for including those as exhibits to testimony, as opposed to using them in cross-examination of the witnesses from whom the depositions were taken. These are not from the deposition of this witness.
Mr. Yar, you've
like
heard my earlier ruling with regard to using actual depositions as opposed to having the witness testify against or testify as to the particular matters. Why do you believe that these are appropriate? For example, it appears there's nothing on the heading that says what this is. It says NM area CCW2, page 1 of 9, and it has a little page 16 underneath it, and goes on to pages that appear to be out of order. It has a little page 16, 17, 18, then it goes to 15, then it has 50, then it has 22, 23, 24, 25. There's no heading on it. To the left hand at the top, it says Peter Tuminello. I believe your witness has identified this as a deposition excerpt. Why should this be in the record, Mr. Yar?
Madam Hearing Examiner, the purpose of this is the reliance by the expert on those statements that were made by the witness, in this case, the BCP applicant's witness.
Does he testify to them in his testimony?
He does not, ma'am, but he has testified under oath during a deposition, which, Madam Hearing Examiner, I think comes in for the purpose that he testified to. I think.
Excuse me, Mr. Yar, this is Hearing Examiner Schaefer.
Yes, sir.
Just a quick clarification. I have trouble with pronouns. So can we just state who is testifying, who the he's are in this discussion? Thank you.
Yes, sir, will do.
And I just want you to clarify. I ask you whether or not he testifies about the subject matter contained in this purported exhibit, and you said no, he doesn't?
No, Madam Hearing Examiner, I misstated that. He does. Everything that that Mr. Tuminello has testified in his deposition that's being used as an exhibit in Mr. Walters' testimony has been testified to at some point in this proceeding. So that's just a
Then why-
misunderstanding.
Then why do I need this hearsay exhibit attached to his testimony?
The testimony supplements what Mr. Tuminello and clarifies, I think, for the record, Your Honor, clarifies the positions of the BCP applicants. This helps, as any other discovery device would, helps clarify the answers that Mr. Tuminello have offered throughout his testimony, his live testimony, and his filed testimony, Your Honor.
Did you have an opportunity to clarify and help supplement the record by cross-examining Mr. Tuminello on whatever purported information is in this hearsay exhibit?
Madam Hearing Examiner, through my colleague, Mr. Gould, I believe we have raised issues similar to, if not identical, to the issues raised in his deposition, Your Honor.
So we already have that information in the transcript of these hearings live. Is that correct?
Without going through the entire testimony that's been filed live, which I have not, Your Honor, I believe that to some degree, those answers have been provided. I think that the testimony of Mr. Tuminello's deposition provides the commission and Your Honor with additional points of data in order for the commission and Your Honors to render a decision and to evaluate this application, Your Honor.
Mr. Your Interim Area Exhibit CCW-3 also purports to be deposition testimony. It says at the top left, Jeff Baudier. Again,
That's
there's
good.
no heading or anything on this. But it says page 1 of 4, and then it says little page 34, 35, 30, 47, 48. Is that correct?
That is correct, Your Honor. We are happy to update these exhibits to make them clear. We believed when we filed them, they were clear, but if for whatever reason Your Honor is not understanding them, we will do whatever Your Honor requires to update them to make them clear.
Same questions, Mr. Yar. Did your witness testify on the subject matter that is purportedly in these exhibits?
I believe so, Your Honor.
Then why would the commission want these exhibits? This repetitive and superfluous exhibit, if it's already in the record?
Your Honor, again, we don't think it's repetitive. We think it gives the commission another point to look at in terms of evaluating this this application. I think if we look at the entire record, it's quite an extensive record. There is many documents that have been admitted or allowed in on the same issue over and over again, Your Honor. It helps the trier of fact and law to understand different points of view. And I think the way our witness is presenting this is a unique view of the same issues that have been testified to and presented. And in that light, I think it provides additional information for the trier of fact and for the commission and for Your Honors to evaluate the validity of this transaction.
Mr. Yar, I really believe, based on my prior ruling, and my consideration of CCW exhibits 2 and 3, and based upon your representation that your witness has testified regarding some of the issues, and you've had an opportunity to cross-examine this purported exhibits witness, witnesses, Mr. Tuminello and Mr. Bodier, extensively at the hearing on these very issues. Um, I, I, I think this is, I think this is inadmissible hearsay that just is repetitive. I don't believe that more versions of the same issue helps the commission at all. Therefore, I'll admit in area 1 and 2, but I will not admit it with CCW 2 and 3. Those have to be stricken.
Your Honor, may I continue?
Yes, sir.
One thing that was not addressed by Your Honor, and I respect Your Honor's decision, is the fact that this objection has been raised with respect to Anna Maria, in my humble opinion, late. This should have been raised as an objection, an in limine motion, when your order required it. I also believe that the BCP applicants have responded to many of these issues in their rebuttal, therefore waiving their objection to some degree, Your Honor. This is really more or less a last minute objection that should have been raised earlier. And by responding to them, Your Honor, which each one of those witnesses, Mr. Tuminello and Mr. Bodier, have done in their rebuttal, clearly waives their objection here of us admitting those. And I think it absolutely helps the commission understand better some of the issues that are raised in this case. But with that said, Your Honor, I'll wait for Your Honor's consideration of my second issue raised, and if Your Honor, I'll stop there, Your Honor.
And I appreciate the attempt to help in enforce the commission's orders. Mr. Yar, thank you. Maybe you could help enforce the one that says please send things to the hearing examiner. That's included in the procedural order too. I take what you're saying very seriously, Mr. Yar, that potentially, and I think Ms. Nanasi also made the claim that it should have been subject to and or concluded in a motion in limine. And that very well may be. But I don't believe that there's any unfair surprise, and I don't believe you're prejudiced by not including these exhibits. And I also believe that in addition, again, I know we were set to go back in the summer and because of the revised application, that people had to pivot and they've done the best they can. I don't disagree with you that it might have benefited us all to have gotten these issues out of the way prior to the beginning of our evidentiary hearing. But I'm also cognizant that people are changing things on the fly, which currently happens in a hearing. People are revising things just like your witness did. I mean, we went through a half hour of changes. So, I mean, that kind of thing happens. That being said, notwithstanding that that technical claim, I believe that as a hearing examiner, excuse me, and representative of the commission, I have an obligation to present the commission with the appropriate factual and legal record. And that includes trying to give them legally appropriate, relevant evidence. Therefore, as I did with NEE's exhibit, I was the one that brought up the issue of the deposition in the first matter, not joint applicants. Therefore, I maintain my same ruling, Mr. Yar, with
Very well.
regard
Very well,
to
Your Honor.
in area exhibit 1. And I believe it's probably past the time. Don't want Mr. Lee to get mad at me. We'll take a 10-minute break and we'll come back at 10:55. Thank you. Remember that the
Madam Hearing Examiner, you're still on video.
A court
How we doing, Mr. Lee?
Good, Judge. I'm ready when you are.
Very well. Let's go back on the record. We're back from our morning recess. Um, Anything further, Mr. Yar?
No, Your Honor. I just want to make sure we're at the point where we're trying to admit Mr. Walters' testimony. It's my understanding that it's been admitted with the exception of those exhibits. Is that correct?
That is correct.
Very well. I tender the witness for cross-examination now.
Very well. Thank you, sir. It is my understanding that only joint applicants have reserved cross-examination time for Mr. Walters. And Mr. Dome, Mr. Dubois, who would like to go first?
Madam Hearing Examiner, this is Brian Haverly, and if it's okay with you, I would like the pleasure.
Please, I believe, Mr. Haverly, that you have reserved 25 minutes.
Yes, ma'am.
Go ahead, sir.
Good morning, Mr. Walters. How are you doing today?
Good morning, Mr. Haverly. I'm doing great. Nice to see you again.
It's a pleasure. We spoke previously in October in your deposition. Is that your recollection?
Yes.
Excellent. Mr. Walters, I only have a few questions for you. So let's begin. You believe that NMGC is a well-run utility, is that correct?
Yes. Yeah,
And you
we discussed that in my deposition, but yeah, I have no reason to believe that they are not well run.
Okay. And you believe NMGC's current management team does a good job running that utility, correct?
Yeah, I think the company's done an overall good job. You know, prior to this case, they've been pretty efficient in settling rate cases. I think that at least I think every rate case under their existing structure has been settled. I was involved in the last one. It's my understanding. I don't recall specifically any negative headlines coming out of New Mexico as a result of NMGC. I'm not saying that they don't exist, but I'm not aware of any. Yeah, I think the company's run pretty well.
And you understand, Mr. Walters, that NMGC's current management team will remain in place if this transaction is approved and will continue to run the company. Is that correct?
Yes, that's my understanding.
And you understand that Emera, the current owner of NMGC, does not run NMGC's day-to-day operations. Is that correct?
They do not run their day-to-day operations, though I believe they've, for lack of a better term, transplanted employees to work within NMGC or work at NMGC, but they do not, as you know, Emera does not run their day-to-day operations.
And you understand that NMGC, from an operations standpoint, is more or less a self-sufficient company. Is that correct?
From an operations perspective, yes, to the extent that, you know, who controls the purse strings allow funds to flow, which I believe they do. That allows them to implement their capital expenditure program that leads to safe and reliable service.
Mr. Walters, you agree that in general, a rate freeze commitment is considered a benefit in merger and acquisition utility cases. Is that correct?
Yeah, there's some benefit to a rate freeze commitment, so long as it's measured accurately and presented accurately. There can certainly be benefit to ratepayers for that.
And you believe that customers generally prefer or strike that. You agree that customers generally like rate freezes in these type of cases. Is that correct?
That could be interpreted. I'm not going to try and opine on what I believe customers may or may not like, because as I think I've pointed out, if we're only doing a few months of delay in filing, but we're accruing additional inflation expenses, I think they would probably rather have a lower rate increase from a timely filed rate case, potentially at least, rather than a potentially much higher rate increase that is the result of accrued expenses.
Mr. Walters, would you please go to what has been marked as joint exhibit number 29, joint applicants exhibit number 29?
Let me navigate my way to the Dropbox. I'm sorry, so you said 29?
29, sir, exhibit number 29.
Mr. Gould, you really need to mute yourself.
Mr. Haverly, just so we're on the same page, this is the appears to be the transcript of my deposition.
That is correct, sir. Do you have it?
Yes, I have it open.
Excellent. Would you please go to page 76, Mr. Walters?
The computer did not like how fast I was scrolling, so it's taking its time. Sorry, sir. It's still trying to catch up and load the pages.
I'm patient. That's fine. Just tell me when you have it.
I know. I just understand you have limited time here, so I'm not trying to eat into that. I just see a square in the middle of the page, and it's just got basically a blue worm going around it. So it's still loading.
And for the record, I do not believe you're playing a game, Mr. Walters. Don't worry about it. We all understand. So just let me know when you have page 76.
I'll try and reopening it. That's not gonna work. I'm just gonna try and download it and see if that is more efficient. All right, sir, I'm at page 76 now.
Wonderful. I've directed you to lines 4 through 9. I asked you if you were contesting whether a stay out rate case was a benefit or if you were contesting that. Your answer on line 6, would you please read that starting on line 6 is your answer?
Would you like for me to read the entire answer through line 18?
No, just this 6 through 9, sir.
Answer, no, no, no. If you look at it specifically, obviously customers don't. Pause. Customers would much prefer paying current rates as opposed to presumably increased rates more in a more accelerated timeline.
Mr. Walters, you understand that in prior commission cases here in New Mexico, the commission has found that a rate freeze is a benefit of an acquisition or a merger case of utilities. Is that correct?
Yeah, it's my understanding that they found that to be a benefit.
Thank you. Madam Hearing Examiner, I have no further questions for this witness.
Thank you. Excuse me, Mr. Haverly. I believe that BCP applicants reserved 120 minutes for cross-examination of Mr. Walters. Mr. Dubois?
You're on mute, Mr. Dubois.
Thank you. Good morning, Mr. Walters.
Good afternoon from St. Louis.
Great.
Sorry, it just turned to 12:06, so
We can have both. Thank you.
nice to see you again.
Good to see you. And we also interacted in your deposition in this matter, correct?
Yes, extensively.
And you still have that exhibit 29 handy?
Yes, I have it up.
Okay. And just to get out of the way, some of the paper part of things up front, could you also please make sure you have available joint applicants exhibit 36? There may be two similar file names in the Dropbox, but we can just go with the one that ends at the number 36. They're the same, they're identical, I'll represent, but for clarity.
I have one that is open that is identified as exhibit number 36.
Okay. And do you also have available the certification of stipulation from commission case number 15-00327-UT? It has marked for identification as NN area exhibit 44 and is in the Dropbox there.
Yes.
All right. Thank you. Mr. Walters, what was your assigned scope as a witness in this matter?
I was hired as to perform an independent assessment of perceived issues in the proposed transaction, and present expert testimony on those matters, those issues that I found in the case.
Was that issues list open-ended and left to your discretion?
Yes.
And was the approach that you took to assess the case as if you were in the position of being a commissioner or hearing examiner?
No, it was not, as I was from that position. I'm not a commissioner or a hearing examiner, so.
Could you please describe the perspective you applied then?
The perspective I applied just as an expert witness and my understanding of the joint or the proposed application, and my understanding of the issues I identified that I thought the commission might find useful in determining their decision in this case, and your honors for that matter. I relied on what I believe to be the factors that this commission has previously applied. And to be clear, it's not a legal opinion, or because I'm not an attorney, I'm not offering as much or as such. But yeah, it's just from my independent assessment of the issues I identified in the case, and I thought that the commission and your honors would find hopefully meaningful in making their determination.
And you're also not an expert in information technology services, correct?
I am not an IT expert.
And you're also not an expert in utility management or governance, correct?
I have not been employed in the capacity of a utility manager or implementing governance practices of a utility. I've been involved in cases where I've testified, or at least been involved in cases where those issues have came up. And I've put forward policy testimony that was accepted as an expert witness, but I've never been employed in the capacity of a utility manager or operator for that matter.
And nor have you been trained in either utility management or utility governance, correct?
I've not been employed by a utility to be trained by that or trained in that matter.
Do you have an academic educational background in utility management or governance?
No, my educational background is specific to economics and finance. Well, I mean, obviously it would be there's general business management coursework that comes along with that. And I've also completed an MBA, but specifically for utilities, no, my academic background was not specific to utilities, but just general business management practices.
Could you please do page 8 of your testimony?
I'm sorry, I could not hear you, the page.
Could you please go to page 8 of your testimony?
On there.
And on line 19 to 20, or 18 to 20, you state that, in your opinion, there is not sufficient evidence to conclude that the proposed transaction will provide any meaningful benefit to the customers, ratepayers, or the public that could not be achieved under the status quo, correct?
Could not be achieved under the
status quo. Is that correct?
You read that correctly.
And it would be more correct in describing your testimony to say that you do not believe there would be any meaningful net benefit, correct?
Objection, Your Honor.
On what basis?
I believe Mr. Dubois is mischaracterizing Mr. Walters' testimony. Mr. Walters' testimony speaks for itself.
Mr. Dubois?
Your Honor, I think Mr. Walters can speak for his testimony and respond to the question on his own behalf. And two, we can further develop the basis for the question if we need to.
I think it's a fair question. I'm going to overrule the objection. Answer if you know, Mr. Walters.
Just so we're on the same page, Mr. Dubois, can you please restate the question?
Why don't we do this? Could you please go to that exhibit number 29, your deposition transcript?
I'm there.
Do you see the question beginning on line 3 and the answer?
What page, sir?
You say what page?
I apologize. Page 26.
I'm there. On line 3?
Yes. With the answer then going from lines 12 to 18.
I see it.
So I will ask, would you agree that while you used the phrase, quote, there is not sufficient evidence to conclude that the proposed transaction will provide any meaningful benefit to the company's ratepayers or the public, end quote, it would be more accurate to say there is not sufficient evidence to conclude that the proposed transaction will provide any meaningful net benefit to the company's ratepayers or the public that could not be achieved under the status quo?
And my answer in my deposition reads as follows. Answer, I believe. I don't disagree with that statement. Again, because when I weigh the benefits, against what I believe to be the deficiencies, I don't know that the benefits outweigh those deficiencies and make it in favor or provide net benefits to ratepayers. So I wouldn't disagree with how you characterize that.
And that is your answer to the question I posed, correct?
Yeah, I don't, yeah, I still don't, I'm still of the opinion that the deficiencies potentially outweigh what has been identified as the financial benefits. So while the qualitative components of the deficiencies that I've identified throughout my testimony, there's not necessarily monetary value to those. So I present it just for, based on my opinion, I believe that those deficiencies, the risks that come with those deficiencies, potentially outweigh the monetary benefits to ratepayers, and I thought it would be useful to the commission and your honors in making their determination in this case.
You do agree that in isolation, the proposed rate credit is a meaningful benefit to customers, correct?
I'm sorry, the proposed
rate credit.
And by rate credit, are you referring to I believe it's now 22.4 million? Is that what you're talking about?
Yes, that is what I'm referring to. Thank you.
Sure. Yeah, that's no small amount of money. It's certainly a financial benefit that the customers, I believe it's being proposed by the joint applicants to spread out on a per capita basis. So, particularly residential, low-income residential customers will certainly enjoy that financial benefit
and
relative to the status quo.
And would you agree that it would not be achieved under the status quo absent the transaction?
I don't know that New Mexico Gas would go out and offer to just give ratepayers $22.4 million. Do they have the capacity to? I don't believe that they are incapable of doing so. But specifically, that rate credit was born out of the proposed transaction. I'm not going to try to say the company would or wouldn't offer out of the goodness of their hearts, if you will, money to ratepayers.
Changing gears, your testimony provides your opinions comparing the relative strength of Emera's balance sheet compared to Saturn Holdco's balance sheet, correct?
I think more, yeah, that it's being compared to the $2 billion in committed funds, or the projected $2 billion in total committed funds.
Could you clarify what the "it" in that sentence was, please?
Clarify what it? I believe we were discussing the balance sheet of Emera to the estimated or projected $2 billion in capital to the funds. It, I guess, would then be the balance sheet or the financial strength of Emera.
And you reviewed the capital structure that would result at Saturn Holdco from the purchase in this transaction, correct?
It's been a few months since I've reviewed proposed financial statements. I don't have any specific recollection of the ultimately final capital structure. I just can't recall off the top of my head right now.
Could you please go to page 40 of your testimony?
Yes, I'm there.
And looking at lines 3 to 12 of page 40, would that refresh your recollection as to that capital structure?
Yes, thank you. Um, yeah, so I think I was just reviewing Dr. Talley's testimony here. I don't know that um, the actual total balance sheet is what I was looking at. I think it was just portions of his testimony. But again, yeah, the ultimate capital structure, I guess, and how the transaction would be financed, being $700 million closing with 450 million in equity and 250 million in debt, with maintaining gas company's equity ratio around 60%.
That is your understanding of the resulting capital structure, correct?
Yes.
And it is actually not only above 60%, it's above 64%, correct? And you're welcome to do the arithmetic.
I had just calculated it while we were waiting. So the specific number I will give you is 64.29%.
Did you?
That's it. Just for clarification and for the record, that's just dividing the 450 million in equity by the total of 700 million used to finance the transaction.
And that's the standard calculation for a capital structure, correct?
Yes. I just wanted, for those that weren't following, to be clear where those numbers came from.
And did you calculate the capital structure of the Amera parent company?
I did, I believe it was right around 30 to 33% equity, at least at the, based on that exhibit, your exhibit 36.
To be clear, you refer to it as my exhibit 36. There's a document that you prepared, correct?
Yes, at the joint applicants exhibit number 36 is a document that I prepared that was born out of our discussion during my deposition.
And if you know, this was, well, I'll start that question over. This exhibit was discussed in your deposition, correct?
Yes, it was.
Okay.
At a very high level, but yeah, it was discussed.
And you provided it following your deposition, correct?
And you
Yes.
provided it following your deposition?
Correct.
Thank you.
Thank you.
And to be clear, just so we're on the same page, this is the one I have pulled up, sir, is the one denominated in US dollars. It does not appear the Canadian dollar one, which I also sent, is presented here. So, but yes, the US dollar, that's what I had sent you.
Thank you. Now, you state in your direct testimony that it is your opinion that the BCP applicant's balance sheet, quote, pales in comparison to the Amera balance sheet, correct?
Can you direct me to that statement?
Sure. Go to page 25, please.
I'm there.
And do you see the heading on lines 10 to 11?
Yes, lines 10 to 11 read section 6, BCP applicant's balance sheet pales in comparison.
And to be clear, in comparison to the Amera balance sheet?
Yes.
And that is your opinion, correct?
Correct. We're discussing $2 billion expected committed capital to the 30 billion in total assets on Emera's balance sheet.
Is it your opinion that the only measure of balance sheet strength is balance sheet size?
It's certainly speaks volumes to the ability to attract capital if it's it's such a large balance sheet. But the capital structure is also often referred to in assessing strength. But you would also glean from other financial statements would be other credit metrics like FFO to debt and
I'm sorry, like
FFO to debt. That FFO stands for funds from operations. It's a credit metric often relied on in assessing financial strength. There's other core credit metrics that are considered. If the company has the ability to have sufficient credit metrics, then that's a sign of strength. But you cannot just glean those credit metrics, if you will, from the balance sheet. The balance sheet pieces simply serve as a provider of some of the components of those metrics.
And you did not review Emera's credit metrics, correct?
I reviewed, not specifically in reading through previous credit rating reports, they would have came up, but I did not review them as far as I did not provide them in my testimony, if you will. I'm sure I ran across them.
You did not weigh them in formulating, providing your opinion, correct?
The credit metrics themselves did not make their way into my opinion.
If you could, let me direct you back to joint applicants exhibit number 36, that balance sheet that you.
I have it pulled up.
And again, to be clear, this is what you use to calculate the Emera capital structure that we discussed earlier, correct?
The 30 to 33% equity ratio that I had mentioned would have came from the figures presented on this sheet. That was just going off memory, what it was from our previous discussion in my recollection off the top of my head.
And in preparing your opinion in this matter, did you weigh the Saturn Holdco capital structure with more than 64% equity against the Emera capital structure with 30 to 32% equity?
And not on a standalone basis. I more relied on the size because I thought it spoke to the ability of Emera to finance and have deep access to capital markets, which would speak to its strength. If you're looking at things in isolation and only in isolation, I would agree that 33 or 30% is not as strong as, say, 64%. But did not look at those in isolation rather than I did the comprehensive balance sheet of Emera and its ability to attract capital and access deep capital markets to finance those assets that are approximately 15 times the projected committed capital of Saturn Holdco.
Are you familiar with other than Saturn Holdco and the BCP applicants, utility holding companies that also have more than 60% equity in their capital structures?
I'm sorry, did you ask if I'm aware of other utility holding companies?
Yes.
That have more than 60%? I would say that I've certainly seen, I can't cite one specifically. I know that in my testimony that I often provide on rate of return throughout the country, I have an exhibit that presents the uh, book value capital structure of the proxy group, which is used to assess the cost of equity. And I've seen those range from the 20% to the 60%. But I can't cite with specific companies that have an equity ratio of that. I just know it exists. It's quite the range for holding companies, and not unheard of to be on those extreme ends.
You would agree that more than 60% equity is a very strong equity ratio in a capital structure, correct?
Again, as I stated earlier, I believe if you're looking at it in isolation and just comparing a 64% equity ratio to a 33% equity ratio, that is indicative of, less financial risk and stronger. But again, as we discussed, I believe the totality of Mira's comprehensive balance sheet of 30 billion speaks to its strength in total.
Well, you identified three considerations of financial strength, one being the size of the balance sheet, the second being the capital structure, and a third being the credit metrics, correct?
Those are three, I guess, sources that you could look at to assess strength. I don't know that they're all encompassing, because there's certainly more than just the credit metrics that I had mentioned. There's more credit metrics than that. Yeah, those certainly are three things you can look at to assess strength.
Would a fourth be the size of the debt and liabilities?
Well, I think that would be encompassed in the capital structure.
So of the three, you looked at the asset size. You did not consider or weigh the credit metrics, and you did not consider or weigh the capital structure, correct?
Well, I couldn't necessarily weigh the credit metrics because I don't believe we have credit metrics of Saturn Holdco in the record. So again, like while I mentioned I had reviewed rating agency reports, which would have included credit metrics of Emira. So that leaves me with size and the various or the relative weights of debt and equity supporting the assets to take into consideration. But again, as I explained, I believe the size of the utility or Emira's balance sheet speaks to its strength and overall financial condition and ability to attract capital and access capital in the market.
Do you believe that asset size on a balance sheet is appropriate to analyze in isolation?
I think asset size speaks to the entire balance sheet, right? Because on one side you have assets and on the other side you have liabilities and equity. So it includes all of that.
Let's try a hypothetical. Assume, please, a company with $5 billion in assets. Do you have that?
Let me write that. $5 billion in assets.
And $4.9 billion in short-term debt.
Okay.
And no cash.
No cash. Okay.
Do you believe that would be a strong balance sheet based on its $5 billion of assets.
So we're looking at one thing here. We're not really comparing it to anything. 4.9 billion in short-term debt, supporting 5 billion in assets. What's the other 10? I guess 100 million. Where's it coming from?
Is that important to your response?
Just for completeness, I'd like to know if I'm going to be presented a hypothetical here.
Why don't we make it $99 million of long-term debt and $1 million of shareholder equity?
99 million of long-term debt. So 0.99. And so then you're talking just so we're clear, Mr. Dubois, you said 0.99 million long-term debt, 4.9 short-term debt, and 0.1 equity.
I'll restate.
So we're over 5.
$5 billion in assets.
Okay.
$4.9 billion in short-term debt.
Okay.
$99 million in long-term debt.
Got it.
And $1 million in shareholder equity.
Yeah, that would be on a total capital structure basis, that would be quite low. It'd be, if I did my math, about 0.0 or basically 0.2% equity. I understood your hypothetical. Because then that 4.9 billion in short-term debt won't be serving as financing 5 billion in long-term assets. It's would be refinanced into long-term debt and equity. 0.02% would be relatively low and something I've not seen in utility finance.
That is not a strong balance sheet, correct?
Just from a financial risk perspective, the over, the 99.8% or whatever it was in debt would, that would be, that's a lot of interest getting paid out every month, or every 6 months, depending on the structure of it. I think I could agree that 0.2% equity is relatively weak on a standalone basis.
So you do agree that one cannot evaluate asset size in isolation away from the capital structure that is supporting that asset size, correct?
That's not what I'm saying. We're looking at one thing here in your hypothetical of $5 billion in total assets, and I don't know what we're comparing it to. If we're just looking at the capital structure, I don't know what 5 billion is in comparison to. I would agree, and I think we discussed this in my deposition, something to the extreme like that would be relatively weak. But I don't think that that's what we're dealing with here in the real world. But if you're looking at your hypothetical in isolation, the 0.2% equity relative to the 99.8% or whatever it is, that would be something I would be hesitant to say is strong.
If you can't evaluate that in isolation, let me give you something to compare it to.
Action, Your Honor.
What are you objecting to, Mr. Yar? He hasn't asked the question yet.
I think he's testifying, Your Honor. He's characterizing his testimony by saying that he doesn't believe he can answer the question. I think he did.
Want to rephrase your question, Mr. Dubois?
To be very clear about your last answer, Mr. Walters, is it your testimony that you can or cannot judge a balance sheet's strength without considering the capital structure supporting the asset base of that balance sheet?
Objection, Your Honor.
What's your objection?
He answered that question already, Your Honor.
I think it was, if not, it's not the exact question, but it's a very similar question. So I'm going to sustain that objection. Move on, Mr. Dubois, please.
Your Honor, if you're sustaining that objection, then going back to the prior question Mr. Yar objected to, I was restating the witness's answer as part of the question I was asking, and Mr. Yar objected to my characterization. So I think I need either to be able to ask the question as I understood the answer, or I need a clarification from the witness and not from counsel as to whether I'm correctly characterizing his answer. I do believe it should be one or the other.
Your first question was, do you agree that one cannot evaluate asset size in isolation away from the capital structure that is supporting that asset size? Correct. That's not what I'm saying. I don't know what we're comparing it to. And then he gives his answer. So you did start out, if you can't evaluate that in isolation, let me give you something to compare it to. So Mr. Yar thought you were characterizing his testimony as not being responsive to the question. And I ask you to rephrase it. So I think you're right, Mr. Dubois. He's saying you can't isolate it, or you can't look at your question in isolation. So go ahead and give him something to compare it to.
Thank you, Your Honor. Are you ready for the next company that you will compare it to, Mr. Walters?
I believe so. So we're going to be developing another hypothetical company to compare the existing $5 billion in asset company.
Correct.
Okay.
Let us say the second company has $1 billion in assets. Are you with me?
I am.
And let's also assume that this second company has $1 billion in shareholder equity.
Okay.
Are you able to compare company number one that had the $5 billion in assets with company two with $1 billion assets in terms of their relative balance sheet strength?
The second hypothetical is 120 or 20% of the size of the $5 billion asset company. However, it's at $1 billion, or it's 100% common equity, which we don't deal with in utility finance. So both of these are the absolute extremes that we don't see anywhere in our space. And again, we're also not taking into consideration the cash flows, but just looking at the size and the relative capital supporting, there's no daily losses that come from financing with debt on the hypothetical company B side. So there's little to no financial risk associated with that. And in the extreme hypothetical scenarios that I'm presented, and on this limited information, I think that I would agree that the second hypothetical company is quote unquote stronger. But it does not speak to their ability to access capital or grow its balance sheet. I would leave it at that.
If you were advising a provider of capital based on this information, would you recommend providing that capital, let's say debt, to the $5 billion asset company because it has a bigger balance sheet without consideration to the other factors?
I wouldn't advise providing capital to either of them without having, I guess, all that information. I'm not a provider of capital. Again, I guess, and am I providing debt or equity capital? What's company A's, hypothetical company A's ability to cover its interest expenses and produce cash flows relative to company B? But if you're just looking at the information you've given me, I would be willing to lend or inject equity into from a risk perspective B, but the company A, debt allows them to have a higher return on invested equity capital if they have sufficient revenues and cash flows. But there's certainly more financial risk that comes with the 0.2% equity relative to the 100% equity.
You would want to know things like cash flows and other credit metrics that you did not consider informing your opinion as to comparing Emera with Saturn or the BCP applicants, correct?
Well, I think what we're dealing with here is, a decades old company that's got a $30 billion balance sheet has proven access or the ability to access capital in all markets, despite its capital structure. It's producing credit metrics that support an investment grade credit rating. And we don't yet know what Saturn Holdco's abilities are going to be and how what those results are going to be. And so I think what we're dealing with here is more than just balance sheet. We're also looking at the ability to access capital and what they're able to do with that capital. So I don't know that it's directly comparable to your hypothetical scenario here. But for if we're just looking at what I've presented in hypothetical scenario, companies A and B. Company B, I would say is in a relatively stronger position, not knowing their ability to access capital markets or generate credit metrics that, well, there's no debt, so the credit metrics wouldn't even necessarily matter.
Can I refer you back to the Emera balance sheet that you prepared?
Sure.
And to be clear, the numbers that are expressed in this balance sheet are expressed in millions of dollars, correct?
Millions of US dollars, yes.
Yes, thank you.
Can you refer to the exhibit?
Yes, the joint applicants exhibit number 36, please.
Thank you.
And how much short-term debt is on this balance sheet?
Short-term debts would be 973.01 million.
And can you explain on the line below current portion of long-term debt, what that phrase means?
Current portion of long-term debt typically refers to long-term debt that is maturing within the next year and is expected to be either retired or refinanced.
And what would other current liabilities be? Just what's on the line below that?
So they've already identified accounts payable. There could be accounts payable to associated companies. There could be other working capital requirements. I'd just have to go back into their actual filing to see what they might qualify to fall into that. But just based on what I'm seeing, it might be working capital liabilities and maybe accounts payable to associated companies. Short-term notes payable, maybe. It's not clear what all is included in that, but those are some potential things that could show up in that.
And how much long-term debt is on the balance sheet?
Under the non-current liabilities header, it says 12.63, I'm sorry, 12,630,000,000 and 310,000.
Would you consider that to be a substantial amount of long-term debt, short-term debt, and accounts payable, whatever substantial might mean to you?
Usually when we're looking at the balance sheet as it relates to utility finance, short-term debt is not often included. So we typically look at long-term debt and common equity or investor supplied capital.
This is not a utility balance sheet, correct?
Well, it's a utility holding company, but like I said, these utility holding companies in my line of work are typically, in my most frequent expert testimony that I do is rate of return testimony and assessing a utility company's cost of equity capital. We review the investor supplied capital from long-term debt and common equity and use it in comparison to the book value, long-term debt and equity of the subject utility in the rate case. It's very infrequent where I look into the specific line items under the current liabilities components, because those are typically then either, I mean, like I said, it's most often looked at through long-term debt and common equity, and to the extent it's on their preferred stock, which is usually quite minimal and not often, but it's another source of long-term investor supplied capital.
Do you apply the same standards to evaluating the financial strength of a utility as you do to a utility holding company?
I'm not sure I understand your question. Can you?
Do you view a 35% capital structure, 35% equity capital structure of a utility as being equally representative of financial strength as a 35% equity ratio in the capital structure of a utility holding company?
I don't know. I've ran across that specific situation in my line of work, where it's been that kind of equity ratio. I've done so many of these cases, but yeah, the holding companies are typically financed with much more leverage than that of the operating company. But because what we do in rate of return work, we're relying on those holding companies because there's market data available for them. And when I mean market data, I'm talking about stock prices, dividend yields, analyst expected growth rates, et cetera, and beta values. So to apply into all these financial models, so you have to use them in assessing the cost of equity of the subject utility company. But the what we typically see is that the holding companies are most often financed with much more leverage than their individual operating utility companies. So the capital structure of the holding companies are used to determine, at least in part, the relative risk, I guess, if you will, to that of the operating companies assessing the cost of equity, because that's while it's imperfect information, it's the information we have.
Is your answer yes, you do apply different standards when you look at the two between holding companies and operating utilities, or no, you do not apply different standards between the two?
I don't know that I'm applying standards. What I'm saying is that when I'm looking at the operating companies, typically in assessing their cost of equity, I'm looking at their capital structure in comparison to the utility holding companies. And I note that the utility holding companies are typically financed with much more leverage than the operating companies. And often those companies take out debt and inject it as equity capital into the operating companies. So, but while it's imperfect information, it's what I use for comparison.
So just to be clear, in your answer, you're talking about your experience in the utility rate making context, correct?
Yes.
Let's refer instead to your experience in evaluating the financial strength of utility holding companies. Can you tell me the last proceeding in which you performed that analysis?
I mean, I assess that in almost every one of my rate of return testimonies, I guess, if you will, when I look at their capital structures and credit ratings and credit metrics. But it's not I guess, centerpiece of my testimony in assessing the holding company balance sheet, unless, of course, the operating company is solely reliant on its parent for accessing capital. That's few and far between. So I can't say here with specific instances where that particular analysis you asked about was completed.
What's the last rate case you testified in?
I've got about 10 going on right now. So that spans several jurisdictions. So I'm currently involved in cases in Wyoming, Ohio, Pennsylvania, Iowa, Missouri, North Carolina, Burke, Michigan,
I'm sorry, the last one, North Carolina,
Michigan.
did you
Oh,
say?
Burke, yes, the FERC, which is the Federal Energy Regulatory Commission. And so,
Thank you. Michigan,
yep, I believe that's where I stopped.
We'll take the Ohio one. What was the utility holding company that was at issue in that one?
The holding company at issue in that case is going to be AEP.
And what was your testimony as to the financial strength of the AEP parent company?
I don't know that AEP made its way into the proxy group, and I guess I should probably stop talking about that one because it is to be filed on Monday, so it's not even yet filed.
Your Honor, I'd like to make an objection.
There's not a pending question.
Well, okay, Your Honor, I'll wait then.
Mr. Dubois?
What's the parent company in the North Carolina proceeding?
Objection, Your Honor.
And your objection, Mr. Yar?
I'm not quite sure what the relevance is of understanding all of the cases that Mr. Walters is testifying in on the rate of return in this proceeding, Your Honor.
Mr.
Your Honor.
Dubois?
Thank you. We seem to be running into some difficulty regarding Mr. Walters' ability to answer my questions regarding how he evaluates holding companies relative to utility operating companies. And I am trying to find a specific example of Mr. Walters' experience that forms the basis for his testimony in this case that would help shed some light on the basis for Mr. Walters' experience and how he actually applies that experience. I think it's gotten tedious trying to get the answer in the abstract, so I thought perhaps we could move the ball by trying it in a specific example.
And I am going to overrule the relevance objection. Because I think it is relevant, but I'm going to sustain the unheard, asked, and answered objection. Because I think you have asked him this question at least a couple of times, Mr. Dubois. He's not answering the question in a yes or no answer, but I think, sir, that the record will reflect he answered the question in the way he was going to answer it. So I think you need to move on, sir.
Thank you, Your Honor. Mr. Walters, let's go back to NM Area 1, your direct testimony, please.
I'm there.
Could you go to page 4, please?
I'm there.
And at lines 1 to 5, there is the question you pose yourself, why did Emera decide to sell NMGC? And then there is a response, correct?
There is.
Are you familiar with any of Miss Hutt's hearing testimony in this proceeding?
I am not.
Are you aware, one way or another, that Miss Hutt testified that Emera is taking a loss on this transaction?
I believe the loss relates to the acquisition premium, if I recall what had been discussed, the relative price to the previous acquisition premium. Is that right? My understanding, is my recollection correct?
I'm asking you, Mr. Walters.
I don't know. I don't know that. I don't know that they are taking it at a loss. Because as I sit here right now, I don't know that, the dividends that have been paid out of, dividended up to the company or to Emera, ultimately have resulted, or if they offset any differences in acquisition versus sales price. I understand that, just that it's been argued that, or it had at least been brought up, that there was a loss. I think that was brought up in Mr. Sandberg's cross-examination, which I went back and reviewed a little bit last night. Albeit that was at midnight.
Is the response that you provide at lines 2 to 5 on page 4 your complete understanding of why Emera decided to sell NMGC?
This is my understanding of their conclusion as laid out in Mrs. Hutt's revised application direct testimony.
Do you have any reason to disagree with your understanding of Emera's conclusion that it should sell NMGC to strengthen its balance sheet?
I wasn't part of their decision-making process. I'm just taking their words for what they are in their testimony. I didn't opine on that. I just simply provided, context for what my understanding of Mrs. Hutt's direct testimony to be and what they decided. Opine on whether that was prudent or otherwise.
In your opinion, would a company concluding that it needs to strengthen its balance sheet and fund future capital investments at other operating utilities provide an explanation for why a utility holding company might sell an asset at a loss?
Again, I'm not trying to agree with the word loss here. So putting that aside, the other components of what you presented, I would believe if that's what they deem to be appropriate for them, in a way of achieving that, then that's not unheard of. I don't know that I agree that they're selling it at a loss, is what I'm saying. But
Well, Mr. Walters, let me be more specific. Basically, in the testimony, there was testimony that with regard to this acquisition premium, that they had taken an impairment and that, uh, and I think there was more than one, but just recently they had taken this impairment and that basically on their books is specifically how she testified. On their books, they're going to show it as a loss. So, I think it's a fair question. I was going to ask you about it. So that's why I particularly think it's fair. I'm just wondering whether or not that, you're you're busy in all these other cases. And if one of these, cases had something like this, how would you view it? Or would you?
So specifically, impairment charges to goodwill or intangible assets are an immediate loss. They're a write down, and it's taken against retained taken against shareholder equity. And it would be reflected in um, their other comprehensive income and loss. So that would, on a specific line item, you're right, that would be an immediate loss, because it's being written against their comprehensive income. What I was saying is, I don't know that that impairment charge is enough to offset the income that they've earned from gas company over their decade of ownership. But I agree that the immediate impairment is an absolute hit to earnings. What I'm saying is their total earnings from that they've earned through gas company might not necessarily be offset by that impairment charge. So yeah, to put a bow on it, it is a hit to the income statement immediately, because it's a write down of an asset that they have to reflect in accumulated other comprehensive income or losses.
So you've categorized it. Would you consider it in making some evaluation, depending on the specifics of what your evaluation would be?
And the impairment charge, I don't know that I would necessarily consider. I would ask for a rephrased question, or at least restate it, because I think we're talking past each other on losses versus potential gain, right?
I
Because
think
we're
ultimately, Mr. Walters, what the commission wants to know from the question is whether or not testimony from the selling company, parent company, that includes or clarifies its justification for potentially wanting to sell, included what was characterized as a loss on the acquisition premium. Whether or not that testimony from a selling company would be important in your evaluation of the financial strength or weakness of that company.
I don't think taking an impairment charge speaks specifically to the financial strength of the holding company. That's just something they weighed in their comprehensive review and divesting itself of that asset, and to achieve
Okay.
their other goals.
Okay, thank you, sir. Go ahead, Mr. Dubois.
Thank you. If you were going to look at dividends received by a holding company in evaluating an ultimate profit or loss, you would also need to look at invested capital subsequent to purchase, correct?
Just so I think, will you please restate that so I make sure I'm on the same page as you?
You indicated that one reason you were struggling with my questions was because you believe that you would also need to look at dividends a holding company seller received over the life of the investment in order to form your opinion, correct?
So the dividend income received by the holding company is essentially its source or a return of capital on its investment in the operating company, and provides a source of income, if you will. And what I'm saying is I didn't compare the dividend income received by Amira relative to uh, the write down of the goodwill asset. And I'm just saying that I'm not certain if the income from one component offsets the write down or loss of the other component.
And you would agree that in performing that evaluation, you would also need to look at capital invested in the utility by the holding company subsequent to purchase, correct?
Yeah, so that'll be presented in their common stock and their additional paid in capital.
Do you believe that, actually, let me start that one over, and I'm going to see if I can get answer to a different question. In the abstract, if a utility holding company is selling a utility asset and says it is doing so to strengthen its balance sheet and to fund future capital investments at other operating utilities it owns, would you find that to be an adequate explanation for why it might do so, notwithstanding that it is taking a loss?
I think that those utility holding companies make decisions like that all the time on what they believe to be their core strategy. So they've weighed the costs and benefits um, weighed that against their objectives and their goals, and that's what they conclude to be reasonable. Then I mean, that's not unheard of.
And did you evaluate the future capital investment needs Emera has identified at its other operating utilities as part of your evaluation in this proceeding?
No, I did not.
Those would be additional demands on Emera's balance sheet, correct?
Potentially.
Could you explain what you mean by potentially, please? If it's not that, then what else could it be?
Well, I mean, if we're talking about utility operating companies, they're not necessarily going to be receiving capital infusions from the parent. They could have retained earnings. They could withhold dividends. Which would be led into retained earnings, and they can also access their own external debt. So, I mean, that's just going to depend on exactly where that capital is going to be coming from, because a lot of times utility operating companies can finance their own capital expenditures through issuing their own debt, and then keeping retained earnings or withholding dividend payments, whatever. That's one way that they could, and I guess the parent company could indirectly finance that.
Retaining earnings at the utility operating company level would make those funds unavailable to service holding company debt or provide returns to holding company shareholders, correct?
It would prevent immediate recognition of or realization of the capital available to holding company shareholders. And I guess the other part of your component of your, they wouldn't be able to use, say, the dividend payments to service holding company debt if they're withholding it.
But you decided not to consider any of that in formulating your opinion about Emera's balance sheet strength and its availability to NMGC, correct?
I have not looked at the individual dividend policies that each of Emira's operating companies are and how they plan on implementing that.
In your deposition, when I asked you why you didn't weigh that consideration, you indicated that you do not have an answer to that question, correct?
I don't recall that question. If you want to point me to the deposition, I'll be happy to review it.
Could you go to Joint Applicants Exhibit number 29, please?
I'm there.
Would you please go specifically to page 18, line 22, onto page 19, line 3, but you can refamiliarize yourself with the Q&A's proceeding as well, if that's useful to you, obviously.
If you don't mind, I'd like to read for context.
Always.
Thank you.
Please let me know when you're ready. I'm not trying to rush you.
No, you're fine. Okay, I'm ready.
On page 18, line 22, you were asked, question, given that, why did you not review that in preparing your testimony and giving your opinions? Answer, why did I not review Emera's capital expenditure program plans for the future? Question-ish, correct. Answer, in offering any of my testimony, question mark, I do not have an answer for you on that, honestly.
You read that correctly.
Does that refresh your recollection?
I don't remember everything for the deposition. I'm assuming that it was transcribed accurately. Don't dispute what you read into the record. It doesn't jog my memory of our discussion. I'm not disputing that that's what I said and what you asked.
Do you have a different answer to that question, though?
Well, I would just I mean, I don't know that the Emira's capital expenditure program. I don't recall in the other cases which I reviewed, specifically the 13 and 15 dockets. I don't recall specifically the commission relying on the selling companies' future capital expenditure programs. So I would say that they relied on the size of the balance sheet and their financial stability in making their determination more so than, say, the capital expenditure plans. But they could be, I agree. I still state that they can be considered important, but I don't recall this commission relying on it in their prior decisions.
So to be clear, is your answer today that you didn't review it because the commission didn't evaluate the selling entity's capital expenditure needs at its other utility holding company?
No, I'm just saying that I don't recall the commission relying on that, which may have prevented me from taking that into consideration. I mean, it could be an important component, but I just didn't review it in context of my testimony in this case.
Neither of those sellers were selling the utility NMGC in order to fund capital expenditures at other utility operating companies, correct?
I don't recall that being a particular issue. Mr. Dubois, I'm sorry, I don't specifically know. I don't have specific knowledge of the strategic component that led them to decide to sell gas company in prior cases, specifically the 13 and 15. I just know that the commission in its decision-making process relied on the size of Emira's balance sheet in making its determination, and particularly in the 15 docket where Emira was the acquiring entity.
Are you aware whether what you're referring to is the 13 opinion or the 15 opinion contained a statement as to why the seller was selling an MGC?
It might be contained in that entire opinion. I think there are 100+ pages. I don't know that I recall every word of those. I know that specifically in the Emira case, the 15 docket, like I said, they specifically pointed out Emira's total balance sheet size of about 20 billion, comparing that to Tico Energy's of about 8.8 billion, and it seemed to have lent itself to being an important component of the commission's decision.
Got 2 minutes, Mr. Dubois.
Is that 2 minutes left of the 120, Your Honor? Or until a lunch break?
I think actually I calculated that incorrectly. You had 2 hours and I put in my calculator or my phone, I put in an hour and 20 minutes, so 80 minutes, so you have 40 minutes left. But if this might be a natural breaking point, I think we might, unless there's objection, stop at this point and let you come back for your remaining 40 minutes after the luncheon break. Is that all right?
Thank you, Your Honor. Yes.
Okay.
Madam-
Just want to also let people know that joint applicants filed the response to bench request 3, so parties should look at that and see if they're going to have any objection to that being entered. And also wanted to check with Ms. Nanasi to see, since Mr. George, I believe, is the next witness, and Ms. Nanasi has also included, I've not looked at it, but has also has a revised testimony. People need to look at that. Ms. Nanasi, is Mr. George going to be available after the luncheon hour?
Yes, and I wanted to get some kind of idea about when you think that would be when I can ask him to be available.
Well, he's the next up after Mr. Walters, I believe, in our order. So subject to the finishing the cross, I'd say a couple hours. And hour and a half. Can't give you a definitive time because I don't know how much redirect there's going to be.
Okay, so are you saying an hour and a half after you determine how long the lunch break is? Is that correct? I just want to make sure.
No, we're gonna go to lunch right now. You know, and we'll come back and if parties can live with 45 minutes, we can come back at 1:15 and continue and And then depending on how much time for redirect, I don't have a significant amount of questions for the witness. I don't know that hearing examiner Schaefer does either. So I would have Mr. George get prepared. It appears that the only party that reserved cross for Mr. George is BCP applicants of 35 minutes. And I have a few questions for Mr. George. So hopefully that narrows your time frame, Ms. Nanasi. Okay, I haven't heard anybody complain about coming back at 1:15, so let's do that. I've got 12:30 now. 1:15 will come back and Mr. Dubois can have his remaining time. Thank you all very much. We are recessed. Please remember the YouTube is on.
I'm ready when you're ready,
Please,
Judge.
checking my audio. Can
Very
you-
well.
I can
Hi,
hear
Mr.
you,
Young.
Mr. Yar.
Thank you, sir.
Only for 4 or 5 questions on redirect, though. That's it. Then your sound's going to go out.
Okay, fair enough.
Just
You
a
realize it is Mr. Lee that's in control, right?
Absolutely, absolutely.
You know, I always say the court reporter rules, so there you go.
Yep.
Just
I'm
want to
ready,
do a mic
Judge.
check real quick. Can you guys hear me okay?
Yes, sir.
Yes.
I was
All
having
right, Mr.
headphone
Lee,
difficulties.
we
Go ahead.
are, thank you. We are back from our luncheon recess. And as I indicated, we're continuing the cross of NM Area's witness, Mr. Walters, and Mr. Dubois. Just to clarify, you still have 40 minutes, I believe, of time reserved. So go ahead, sir.
Thank you, Your Honor. And I still aspire not to need it, but we'll see.
I'm much happy to accommodate the 2 minutes, Mr. Dubois. I liked your honors math earlier.
Yeah. Good afternoon, Mr. Walters.
Good afternoon.
You are aware, correct, that New Mexico Gas Company, NMGC, receives a credit rating from Fitch?
Yes.
And are you aware that Fitch has opined on the credit impact of this transaction?
I'm trying to recall, I believe that was presented in one of Mr. Shell's testimonies or attached to. I want to say that it was credit neutral, if my recollection serves.
Did you take the fact that Fitch views this transaction as credit neutral into account in your opinion and analysis?
I certainly reviewed it. I think neutral speaks to itself. It's not detrimental or necessarily credit enhancing at the moment. So I didn't think there would be much to. I don't think there would be much to glean from neutral.
Is that why you did not mention it in your testimony?
I don't know. If the just surmise that if the rating agency found it to be neutral, it's not improving or enhancing a detriment to their credit position as it is now. I don't know if there would have been much to gain from that.
Would you please go back to NM Area Exhibit 1, your direct testimony?
Sure, I'm there.
And point you to lines 14 to 15, where you state, quote, "These are standard provisions often proposed in utility acquisitions," end
Page
quote.
number.
Oh,
I'm so sorry. Page
Yep.
number, please.
Yep. Page 39. And
I'm at page 39 now.
I'm going to ask about lines 14 to 15, but please go ahead and take a moment.
Okay.
And on lines 14 to 15, you state, quote, referring to, start over. You're referring to ring fencing provisions when you use the word these.
I'm sorry, you're referring to rate, you cut out a moment.
Referring to ring fencing provisions when you use the word these on line 14, correct?
Yeah, these are referring to what is discussed above in line, the ring fencing commitments that are discussed lines 10 through 14.
Well, to be specific, it's ring fencing commitments that include those specifically stated on lines 10 to 14, correct?
Yes.
Could you please identify other transactions of which you are aware that have the same set of ring fencing provisions that are proposed here?
In my experience, like I said, these are just general or standard, um, in some capacity. I mean, I was involved in the Elite acquisition. There were several, if not all, of these provisions that were in similar nature. And just ensuring that, for example, as it comes to the credit rating, ensuring that ratepayers there's often a concern about debt above the utility operating company and holding ratepayers harmless for any changes in the cost of capital that could result from changes in credit rating. So essentially maintaining a credit rating is a way of, I guess, holding ratepayers harmless and ensuring that the operating company's financially okay.
All of the ring fencing conditions that are proposed here contained in the Elite transaction that you're referring to?
You cut out for a second, Mr. Dubois.
Were all of the ring fencing provisions that are contained in the application in this proceeding contained in the Elite proceeding that you reference?
I can't say with, specifically if they were or weren't. I'd say there's going to be a ton of, or a lot of overlap in the commitments as far as ring fencing is concerned. It's been going on 11 months since I testified in that case, or at least presented my direct testimony in the case. So I don't recall exactly what ring fencing provisions, but just reading through what I'm discussing here is relatively consistent with what my experience is in other acquisition cases.
Did you conduct any side-by-side comparisons between the ring fencing in this proceeding and those in any other proceedings?
I looked at the provisions, I guess, in the 13 and 15 dockets, but I didn't compare. Like I said, I didn't do a direct comparison of the Elite acquisition commitments compared to the commitments presented in this proposed transaction.
Is it your testimony that you understand the ring fencing provisions proposed in this transaction to be the same as in the 2013 and 2015 transactions involving NMGC?
Can you say that again, please?
Is it your understanding that the ring fencing provisions that are proposed in this transaction are the same as the ring fencing provisions contained in the 2013 and 2015 NMGC transactions?
Nothing stood out to be significantly different. I would say that they're probably, I recall them being relatively in line.
Can you define relatively in line, please?
Relatively consistent with what was in those dockets. I mean, I didn't think there would be much controversial here. Like I said, I think they're pretty standard commitments. I'm not taking issue with what I don't believe.
Would it surprise you if there are more commitments in this proceeding than there were in those?
Would it surprise me? No.
But you don't know.
I don't have like a list by list comparison side by side of everything. What I just summarizing there are standard provisions or conditions. But I don't have in front of me, if you will, or have I prepared a side by side comparison. I don't have a document that lays each of the commitments out from each of the dockets and says, or compares and contrasts them. Just based off my reading of those documents, the 13 and 15 orders and what I understood to be a Mr. Talley's testimony, that there's some overlap And the ones that I've identified, like I said, they're standard.
Did you review the ring fencing conditions that are proposed in this proceeding yourself, or did you just look at Dr. Talley's testimony?
I would have looked at them at the very beginning, but I didn't take particular issue with the ring fencing provisions. So I just really referred to Dr. Talley's testimony.
Could you go to page 41, please, of your testimony, NM Area Exhibit 1?
Sure.
And I'm going to have a question about lines 9 to 12, but please go ahead and refamiliarize yourself.
Okay.
I'd like to ask you about your reference to there being additional holding company layers. Can you explain what you mean by that, please?
Yeah, I think it was identified in Mr. Talley's testimony that the proposed structure post close is largely consistent with the existing structure, with the addition of, I believe, one additional holding company above New Mexico Gas.
Did you look at the side-by-side comparison of the holding company structures yourself?
I mean, that's presented, I believe, in Mr. Baudier's JMB3 that I believe was attached to his direct testimony, if memory serves. And I would have reviewed that.
You would have, but you don't recall.
I mean, I'm looking at it right now. I have seen it.
Are you aware of there being a number of other companies in the Emera holding company structure that are not direct parent companies in the line above it, including other operating utilities that are not depicted here?
Yeah, I mean, Emera's corporate structure is going to be far reaching, if you will. There's going to be a lot more companies that aren't listed here because they've got operations elsewhere that aren't provided in the pre-closing structure provided in Mr. Baudier's JMV3. I couldn't tell you how many or what those companies are. There's a lot of them.
And you deemed that to not be relevant to your analysis of Emera's financial strength and holding company structure?
I mean, the holding company structure, the $30 billion in asset would be a consolidated balance sheet after all those companies are incorporated. I'm just saying that what's presented on Mr. Baudier's JMB3 doesn't include all those companies.
Is that a yes, that you do not believe the rest of the holding company structure to be relevant?
It could be, but I'm just, it's not presented here in this case.
Could you go to page 40 of your testimony in NM Area Exhibit 1, please?
I'm there.
And I'm going to ask you about the sentence at lines 7 to 10, but please go ahead and refresh your memory.
I'm there. I brought it.
You use the phrase there, even if labeled non-recourse, referring to debt. Do you see that?
I do.
And non-recourse or recourse as a distinction is not a simple matter of labeling, is it?
No, I mean, that would be, I guess, part of the the ring fencing separations, meaning the debt at the parent company cannot be, in the event of default, the utility can't be divested to satisfy those debts, if you will.
Is that what you think non-recourse means?
I mean, the utility company can be held liable for parent company debt, is, I guess, generally speaking.
What did you mean to convey by including the word labeled in that phrase?
Um, differentiating between non-recourse and recourse.
Well, you agree it's a substantive difference between recourse and non-recourse, not just a labeling difference, correct?
Sure.
So is the word labeled there just gratuitous and we can ignore it?
Objection, Your Honor.
What's the nature of your objection?
Your Honor, he answered the question. What the definition, why he put the word labeled in there.
Mr. Dubois?
I think it's a reasonable question to ask and an appropriate question to ask what he would like the commission and the hearing examiners to take away by including a word that from our prior colloquy seems not to be necessary there.
Mr. Walters, did you mean anything by the word labeled?
I don't think the word labeled has significant meaning in the sentence necessarily.
Thank you. Go ahead and ask your next question, Mr. Dubois.
Thank you, Your Honor. Did you, Mr. Walters, re-review the...
I'm sorry, Mr. Dubois, I can't hear you. You were cutting out.
Subsequent to preparing your testimony in this proceeding, have you re-reviewed case number 15-00327-UT's certification of stipulation?
I have reviewed in preparation for this hearing that certification stipulation and the commission's final order on it.
And do you recall in that certification of stipulation weight being given to Emera's intent to rely on a New Mexico Gas Company, local board, local management, and local operations?
That sounds familiar.
You did not address it in your testimony, however, correct?
No, I don't speak to that very much in my testimony, if at all. I'm more focused on the other components that I thought the commission deemed important in their decision.
Did you evaluate the size of the rate credit in case number 15-00327-UT?
I mean, I looked at it. I don't recall what it is off the top of my head. But I didn't specifically take issue with the rate credit proposed in this case relative to what it was in the last case. So, I mean, that wasn't a central theme of my testimony, so I didn't keep that in mind in and what it was.
Was comparing the size of the benefits in this transaction relative to the 2013 and 2015 cases a theme of your testimony in this case?
The theme of the testimony in this case focuses on primarily the concerns I have with what this commission has deemed important in prior cases, specifically where I thought this company was, or this proposed transaction was lacking. And that was relative balance sheet size, acquire experience, and then additionally, I thought of concern was the frequent transactions in which, or the frequency in which New Mexico Gas is traded hands and proposed to trade hands, and is that inevitably going to be traded hands again should this case or this acquisition go through. So while I reviewed it, I did not take specific issue with the size of the rate credit in this case relative to the one in the prior case.
Are you saying that in formulating your opinion, you did not consider the relative size of the rate credits?
I'm saying I reviewed it and did not take issue with it.
Mr. Walters, are you able to give me a yes or no answer to the question whether you considered the relative size of the rate credits in the two proceedings? This proceeding relative to the case number 915-00327 proceeding and formulating your opinion?
Objection, Your Honor.
What's the nature of your objection, Mr. Yar?
The question has been asked and answered.
Mr. Dubois?
I asked a yes or no question. I got a long answer that I don't believe contains an answer even other than yes or no to the question I actually asked. I'm now asking if the one that I asked is susceptible to being answered by the witness.
I'm sorry, go ahead, Your Honor.
Mr. Yar?
I believe Mr. Walters had clearly answered his question by saying that he did not take into consideration the rate credits as they relate to the 327 case. And I think that's an answer to his question. I think Mr. Dubois wants a yes or no, but the answer is there.
If Mr. Walters agrees with Mr. Yar.
Hang on.
I'm sorry, Mr. Dubois, you are cutting out.
He doesn't say he was asked, was comparing the size of the benefits in this transaction relative to the 2013 and 2015 cases, a theme of your testimony. And he says the theme of the testimony in the case focuses primarily the concerns I have with what this commission has deemed important in prior cases. And then he answers, I did not take specific issue with the size of the rate credit in this case relative to the one in the prior case. So I'm going to overrule the objection because I don't know that he's identified in his prior testimony that he was referring to the 15-00327 case. So on the basis of that, Mr. Walters, answer if you know.
Sure. So I would refer you to page 9 of my direct testimony where I lay out what I considered in this case. And I do not mention the rate credits, in this case relative to the last case, as a concern. And I would say that more dollars is always nice, but I don't think that those don't necessarily overcome the other deficiencies in which I've identified that for this commission's consideration. So nowhere in my testimony do I discuss one way or the other the rate credit, in this case, to prior cases.
And
Mr.
you all,
Dubois?
thank you. And Mr. Walters, you also do not believe the size of the rate credit is relevant to the commission's consideration, correct?
What I said was I don't necessarily believe that more money to the ratepayers outweighs the deficiencies that I've identified that this commission has deemed important, being operating and ownership experience of regulated utilities and relative size. So there are some qualitative, intangible benefits that cannot necessarily be quantified, or issues that cannot be quantified that I weighed against the totality of the rate credit, the financial benefits. And I would note that there's been I take issue with some of the financial benefits identified, but one of them was not the identified rate credits of initially 15 million are now 22.4 million. So that wasn't a central theme of my consideration.
Mr.
Or my
Walters,
opinion. I'm sorry, or my opinion for that matter.
Mr. Walters, could you please focus on answering the question I'm actually asking and not describing your testimony or prior answers otherwise? Question is, do you believe it is relevant to the commission's consideration to consider the size of the rate credit in this proceeding compared to those in the 2015 and 2013 proceedings?
Yes, but it should be considered against the backdrop of the other issues in this case.
And your testimony purports to be an analysis pursuant to the 6-factor test, correct?
I discuss a handful of the six factors in the 6-factor test, yes.
But you do not mean for the commission or the hearing examiners to understand your analysis to be complete then, correct?
What I'm saying is I did not present or address the rate credits as an issue in this case, and therefore I did not provide discussion around it in this case. The issues I identified dealt with operating and ownership experience or lack thereof. The commission also deemed the size of the balance sheet to be an important factor, and I'm also concerned with the frequency in which New Mexico Gas has traded hands. The commission can certainly view the financial benefits as important considerations. They are, I mean, that's part of the fact, one of the factors is part of the benefits. Now, if you're looking at weighing some of the costs or detriments against those benefits, that's where they would make their determination. I presented concerns I have with what I've believed to be significant deficiencies or shortcomings.
Your Honor, I don't believe that to be an answer to my question at all. Can I either re-ask it without it being asked and answered, or have an instruction to the witness to answer my question?
Mr. Dubois, I believe the witness did answer your question. It may not be the answer you're looking for, but what I heard was an answer to the question. So I'm going to deny your request for an instruction and ask you to move on to your next question, sir. You have approximately 10 minutes.
I'll stop there, Your Honor. Thank you.
Very well. Thank you, sir. I do not believe that any other party requested cross-examination time. So at this point, I would ask Hearing Examiner Schaefer, do you have any questions for Mr. Walters, sir?
No, I do not, Madam Hearing Examiner. Thank you.
Thank you. Good afternoon, Mr. Walters. I've just got a few questions for you. I think I understand your testimony. But I'd like to know when, just for clarity of the record, when you testify on page 1, as to whose behalf you're testifying for, and you refer to New Mexico Affordable Reliable Energy Alliance, or NM area, you testify on page 1 of your testimony at lines 15 through 17. NM area is an organization comprised of large utility consumers who are customers of New Mexico Gas Company. Is that right?
Yes, ma'am.
So these large utility consumers are what type of entity? In other words, are they individuals? Are they businesses? Are they industrials? Who are these large utility consumers, if you know?
I don't know the specific companies or businesses or industrial users or whoever might be members of NM area. This was conveyed to me through conversations with counsel. But I don't have specific knowledge of each of the individual members. I'm sorry, I would say, I would assume that there are some large industrial businesses that are part of that.
Okay. Do you know what rates they take service from gas company?
No, ma'am.
If there's some industrials, is it fair to say that they don't take under the same rates or even potentially under the same type of service that the residential customers do?
I think that if in that scenario, I would think that that's a fair assumption.
Well, do you believe that depending on what type of rate group or what kind of service you receive from a public utility, that your interests might be different than that of another consumer who takes under a different type of service or who takes under a potentially different rate from the public utility?
Maybe. I'm not trying to present myself as a rates expert. I'm not a cost of service allocation rate design expert. So, but I mean, in each of these regulatory proceedings, there's various intervener groups that represent various interests that take rates in service at different levels, and so, and a lot of times those can be differing. It's usually not an issue when it comes to like revenue requirements and stuff like that. It's more of specific interest or cost of service and rate design. But the potential is there, but I don't touch on that. That wasn't part of my scope in this case.
Well, what I'm what I'm wondering is usually when I see in a rate case or some other type of utility case, when I see in an area or I see FEA or some of the large users, they usually have an interest in what their rates are gonna be, as opposed to someone, say, like the low income intervener who's concerned for that particular type of consumer. Is that fair?
Yeah.
So what I'm trying to, excuse me, what I'm trying to understand here, I'm going to cough again just a second. Okay, I'm going to try that one again. I can understand, for example, that the rate credit that Mr. Dubois was just asking you about and how that rate credit would be calculated, excuse me, might be of interest. And that there might be disparate interest depending on whether an intervener was representing a large industrial as opposed to a low income group. Can you see that those might be disparate interests?
Yeah, I mean, I think if I recall, I want to say it was I think it was the FEA's witnesses testimony that I think he came in rebuttal and discussed the, um, that, where the rate credit was being proposed being spread out on a per capita basis relative to some other, method in which he proposed. I don't recall off the top of my head. So yeah, I mean, just intuitively thinking, the residentials would get more benefit of a per capita distribution of the rate credits than, say, large customers. It'd have more relative impact, benefit to residentials than, say, a large customer, right? If it's just on a per meter basis or per account basis. And that's certainly something that NM areas constituents might be concerned with. I just was not hired to. I'm not a rates expert or cost allocation or cost of service expert, and that's just not my area of expertise. I don't know what efforts NM area took to address those concerns, but that was not what I was hired to do in this case.
So you didn't look at, for example, the rate credit issue as to whether a volumetric allocation of that credit would be more beneficial to your client.
If it was on a volume metric, and if I understand, operating under the assumption they are large industrial users, volumetric, they would certainly benefit more than, say, the residentials than they would under a per capita basis. that's just based on my general experience and knowledge. But I'm not trying to suggest that I'm, again, a cost of service or allocation expert, and that's not what I was hired to look into.
Okay. So you don't know then, for example, when you say NM area is an organization composed of large utility consumers, you don't know what that means.
Well, I don't know how large, like what large is, right? I mean, it's good. I'm
Are
comfortable
they
saying
big
that
people?
I'm, their consumption of gas will be larger than I assume any a typical residential would be, um, but not like relative in size of a person.
Okay.
But that's
But
just
you
based
don't
on
know.
I don't, like I said, I don't have specific knowledge of any of the companies that are within NM area as we stand here today.
Okay. The so you didn't look at that aspect. Um, did you look at the transaction at all from the perspective of if the acquisition is approved, will my client service potentially be threatened?
So
So,
I'm sorry, Your Honor.
oh, I
Please,
was
if you
just
want to
gonna,
clarify.
yeah, I did. If so, in other words, if is there some concern on your part that there's going to be an interruption in service? That um, that there are some kind of actual physical constraints that your client wouldn't that would change your client's uh service that it receives from New Mexico Gas Company.
So I would refer you to the concerns and conclusions that I present on page 9, where I present in bullet points several of my concerns in this case that I've identified, and I think at least a couple of them can speak to or kind of address factor 3, which is whether the quality of service will be diminished. And I think a few of them can certainly um, be uh, go into that factor 3. Specifically, I think, let's see, the fourth bullet point where it says there is an increased risk to NMGC and its customers given the BCP applicant size relative to Emera. BCP's balance sheet is much smaller in scale relative to Emera's, potentially limiting access.
I'm sorry. Can you repeat after relative to Emera and start again, please?
After relative to Emera's, it says potentially limiting access to external capital at reasonable terms and prices. So I think that could potentially have service quality issues. And the final bullet point in that list, which reads, "This is the third time an MGC will have been a party to an acquisition since 2014. The BCP applicant's commitment to a 10-year minimum holding period all but guarantees NMGC will be divested at some point in the not so distant future." I think that could also be or affect factor 3, which is again whether the quality of service will be diminished. As I said in my testimony, the frequency on which NMGC has traded hands is concerning, and it can potentially lead to instability to both employees and customers. So I'm not saying it definitively does. I'm saying there's a risk there that it can have service quality issues. Um, and relative to current, as I discussed in my earlier cross-examination, I think gas companies quite well ran, and nothing stands out as you know, negative as far as service quality is concerned now. But I present it as a possibility for that to happen based on those two concerns I just read you from my testimony on page 9.
Well, with regard to the last part of your testimony, is there anything that you can point the commission to in the last two acquisitions of gas company that resulted in what you think could happen now?
Not specifically, like I said, the company, I don't have any recollection of the company having poor service quality. I'm just saying that the risk is there and the commission should consider it.
Well, how should,
I'm sorry.
go ahead.
I don't have any reason to believe that it will in fact impact the service quality in a negative fashion. I'm just saying that the risk is there.
How should the commission evaluate that risk, Mr. Walters? I mean, if the if Emera wants to sell the company, or if any public utility wants to be sold, uh, and they come to the commission and they prove their case, I mean, there's no rule on that, oh, you can only be sold every 50 years, or you can't be sold more than 10 times in 25 years. So what would you suggest that the commission do to try to put the um the acquisition numbers or acquisition risk into perspective?
That's a good question, and I don't necessarily have a definitive answer. What I'm saying is that this company's traded hands more times than I can recall any other utility in my experience trading hands, and we're just going through this whole process. We're guaranteed to go through this whole process again if it does. If this transaction does go through, and you're dealing with a utility that has long-lived assets that's certainly longer than 10 years and requires planning for longer than 10 years. So trading hands every 10 years does not promote stability in my mind. I don't have any quantification or specific examples that I could point the commission to. It's just a concern, and I'm unaware of any other utility trading hands. This is the proposed now 4th time, I guess, since 2008, and the 3rd time since 2014. And I'm just here to highlight a potential risk for the commission's consideration. Certainly, Emera is, they committed to a 10-year hold. This commission has accepted it as such, and that 10 years is up. And they've done a portfolio review and determined that they would like to get rid of the gas company. I'm just concerned with the frequency in which it is happening. So, like I said, it's just a highlighting of my concerns.
Okay. Well, have you considered that maybe it's I think according to your words, that it's a well-run company, right?
Status quo, the company is very well run.
And it looks like from what I've seen that they're paying dividends, right?
Yeah, they're paying dividends. I think that part of their capital structure policies to, they pay or retain earnings, pay out or retain earnings to maintain their capital structure around, I believe their equity ratio is 52% on a regulated basis. So, to answer your question, that I do still believe that they're a well-run company, and they have paid dividends.
Did you happen to review or listen to any of the public comment regarding the community's feeling toward the company?
No, ma'am.
Would it surprise you if I said that the comments were generally positive of
Wouldn't
the of how they felt about their gas company?
wouldn't surprise me at all. I did hear to compliment that. I did hear Mr. Sandberg in his cross-examination when I was listening to it last night, the recorded version, that he himself said he was a customer and he was happy with gas company service. So
So
I did hear that comment, if you will, but I did not listen to the others, and I'm not surprised that other people are happy with their service too.
well, do you think if you were in the market for a company, a utility company, for, whatever reasons that you wanted to get into the utility business, wouldn't you want a company that was well run, was liked in the community, and that paid dividends?
On one hand, yes, I guess it's really what's your objective, because if your objective is to try to buy a utility at a discount, you're going to look for one that you think is not ran well, in which you can capitalize, buy at a discount, flip it, and make more money. But I guess it's really what your objective is and your investment risk, or your investment thesis is. And so yeah, there's various investment styles. So I guess it really just depends on the buyer.
Okay.
And that the proposition you just laid out is certainly one that could be considered.
Well, are those three characteristics well run, liked by the community, and pays dividends? Could it be said that not all public utilities do those three things? Or
There are
any of the three?
well, I think one and two, meaning if they're not well ran, they're certainly not going to be liked in the community. There's going to be service quality complaints out the wazoo. And I'm sure I'm sure there's instances where utilities have failed all three of those criteria. Can't sit here and say that I know of anyone specifically. But yeah, it's possible.
Very well. Thank you, Mr. Walters. I appreciate your time, sir. Mr. Yar, any redirect for your witness?
Yes, ma'am, I have some.
Go ahead.
Thank you. Mr. Walters, do you recall the question from Mr. Dubois and the hearing examiner about the acquisition premium in this case?
Yes.
In either the TICO case, which is 13-00231, or the Amira case, did the commission consider the seller's acquisition premium?
I think what I recall from either of those dockets is the only consideration that the commission concerned itself with as it relates to, excuse me, I've got the cough soon. As it concerned the acquisition premium, was whether or not it was going to be recovered by ratepayers. So that there's the commitments that that the acquisition premium not be recovered directly or indirectly by ratepayers. Excuse me. Sorry.
Okay. I got a cough too. As far as you know, Mr. Walters, from those certifications, did the commission cite to the seller's gain or loss on the acquisition premium as a factor in the six-factor test?
I don't have any recollection of that being a concern of the commission or cited by the commission in its order.
Do you recall Mr. DeWaz asking you questions about Emira's motives for selling New Mexico Gas Company?
Yes.
In the TICO case or the Emira case, did the commission consider the motives of the seller as part of its six-factor test? As far as you can recall.
Not to my recollection, no.
Okay. So if we go to that case, I believe it's NM area exhibit.
Which case, sir?
I'm sorry, this is the 13-2, the 13-7, the 327 case, the 15-327 case, I'm sorry.
What exhibit number was that?
Exhibit number 44. And I'm pulling it up as we speak.
NM area 44?
NM area 44, yes, ma'am.
There it is. I've got that. To be clear, it's the certification of stipulation case number 15-00327-UT.
That's right.
I've got that pulled up, sir.
Okay. Do you recall in that case, the commission going through, or at least the hearing examiner and the commission ultimately approving the 4 factors and then ultimately the 6-factor test?
Yes.
That's on page 31, I believe, of it.
I don't want to scroll too fast because that froze my screen earlier, so I'm going to take my time getting to that. Yes, I'm there.
Okay, and if you could please take a look on page 31, the first full paragraph of that certification. Would you mind reading that?
Starting with in case 04?
That's correct.
And how far do you want me to go?
Just until the 4 factors are read in.
Sure. In case 04-00315-UT, the NMPRC identified the following 4 principal factors as bearing on whether a transaction satisfies the 62-6-13 standard for approval. 1, whether the transaction provides benefits to utility customers. 2, whether the NMPRC's jurisdiction will be preserved. 3, whether quality of service will be diminished. 4, whether the transaction will result in the improper subsidization of non-utility activities.
I'm sorry, can you read 4 again, please?
Certainly. 4, whether the transaction will result in the improper subsidization of non-utility activities. And then underneath that, it says certification of stipulation 17.
And then would you go ahead and read the next paragraph, which, yeah, if you would please read that.
You have a question on on that particular Hart, Mr. Yar?
I'm getting to it. If you would just give me a little bit of leeway, Your Honor, I just want
Okay.
to make sure we're laying the proper foundation.
Go ahead, sir.
In case 11-00085-UT, the NMPRC applied the 4 factors identified in case 04-00315-UT and stated that 2 additional important considerations in a stock purchase case are, quote, careful verification of the qualifications and financial health of the new owner and adequate protections against harm to customers, end quote. Recommended decision 16.
Thank you. And what I'd like you to do is also quickly take a look at those bullet points and just become familiar with them. I want you to review them, make sure you're comfortable with them. Take a moment.
Which bullet points, sir?
The ones that says no adverse impact on utilities existing rates. Just
Okay, I
read
see what
through
you're doing.
those and familiarize yourself with them, please. And let me know when you're ready.
Yeah, I've read through those bullet points.
Okay. In any of those cases, as far as you can tell from what you've read, did the commission consider motives of the seller?
Based on the bullet points, the seller's motive for selling was not attached as to its approvals or considered.
Nor the loss, too, correct?
Correct.
Okay. Switching gears a little bit on some of the questions that were raised by Her Honor, the hearing examiner. Do you recall the questions about how well New Mexico Gas Company is run?
Yes.
Isn't one of the factors, one of the considerations, whether it would continue as a 6-factor test, it would continue to be well run if sold to a potential startup?
Could you restate the question, Mr. Yar?
Sure. What I'm asking is, isn't one of the factors, or under the 6-factor test, isn't one of the considerations that the commission should consider is whether or not the acquirer would be a company that would continue to support or have the New Mexico Gas Company run properly?
Yeah, I think factor 3, whether the quality of service will be diminished, and factor 6, whether there are adequate protections against harm to customers, could potentially play into that.
That's right. Factor 6, whether there are.
I'm sorry, sir. Whether there are adequate protections against harm to customers.
Thank you.
Madam Hearing Secretary, that's all the redirect that I have.
Very well. Mr. Haverly, any redirect based on, or any recross based on my questions or the redirect?
Madam Hearing Examiner, I have very limited recross, and it is based on questions that you asked the witness. If you'd indulge me.
Yes, sir, go ahead.
Okay. Mr. Walters, are you aware that New Mexico is an open carriage state, then that customers are able to arrange for their own gas purchases outside of New Mexico Gas Company?
Say that again? Open what?
Carriage state, meaning that customers can buy gas from third-party shippers and not directly from the utility. Are you aware of that or not?
Not specifically, no.
Madam Hearing Examiner, then I have no additional questions.
Very well, thank you, Mr. Howerly. Mr. Dubois, any recross based upon my questions or the questions of the redirect of Mr. Yar?
Very limited, please, Your Honor.
Go ahead.
Mr. Walters, are you aware that in a different utility acquisition case, the commission did consider the seller's reasons for selling the utility?
In New Mexico?
In New Mexico.
Not specifically, no.
Did you review any commission cases other than the 2013 and 2015 NMGC cases we've been discussing?
At the beginning of my review of the case, I also looked into briefly the Avangrid P&M proposed transaction. And I discussed that very briefly in my testimony. I think the 13 and 15 certification and stipulation orders on those cite heavily the 08 docket, which NMGC was a party to the case. But that's what I've reviewed.
Do you have the certification of stipulation in case number 13-003? I'm sorry, case number 13-00231 in front of you?
Do you know what exhibit number that is, sir?
Let's see if I can find it quickly. Or if somebody else can tell me what it is. NM area exhibit 43.
I'm there.
Would you go to page 58, please?
Give me a second. I'm not trying to freeze my computer again by scrolling too fast. Did you say 58, sir?
I did.
Almost there. I'm there.
Would you please take a look at the two paragraphs beginning with the first full paragraph starting in case number?
I was on page 59. I'm sorry.
Mm-hmm.
First full paragraph beginning in case number 11-00085-UT.
Correct.
The NM. I'm sorry.
To be clear, I wasn't asking you to do a read aloud. I was just asking you to be ready to answer questions.
Give me just a second if you don't mind. I've read that paragraph.
Does that refresh your recollection that, to the contrary of what you told Mr. Yar, the commission did consider the seller's motives in evaluating the transaction?
The seller's motive is at least in part laid out in that paragraph. And which the commission relied on.
And in particular, the seller, quote, declared its intent to divest its water utility holdings in the Southwest to focus its business in other regions.
I'm sorry, you broke up just a bit of the seller quote.
Quote, declared its intent to divest its water utility holdings in the Southwest to focus its business in other regions, end quote. Correct?
Yes.
And the commission contrasted that with the purchaser wanting to hold the utility, correct?
Yeah, in contrast, EPCOR's acquisition of NMAW and another utility in Arizona manifested its asserted long-term objective to expand its operations in the Southwest. Emphasis on the long-term objective.
I'm sorry.
I'm emphasizing emphasis on long-term objective. The commission did not emphasize it in that paragraph.
And then in the following paragraph, the commission stated that TECO's objective to own NMGC, in contrast to Continental's objective to sell NMGC, was a benefit, correct?
You did read that correct.
So your answers to Mr. Yar regarding the commission's prior cases that you said you reviewed were not correct. Correct.
My recollection would not have been correct. Again, there's a ton of pages in these and a ton of data throughout this case. But that particular paragraph would be counter to what I have said.
And you did not consider that in your analysis in this case, correct?
This particular paragraph did not make its way into my analysis.
Thank you. Thank you, Your Honor.
Thank you, Mr. Dubois. Mr. Walters? Thank you,
Yes,
sir. Appreciate your time. You are excused.
Have a good day.
Same to you, sir. Let Mr. Yar, I see you've raised your hand.
I have, Madam Hearing Examiner. I just want to, if this is the appropriate time to talk about how to deal with those exhibits that were previously ruled inadmissible.
And that would be CCW 2 and 3. Is that correct?
Let me double check. CC2, yes, ma'am, you are correct.
And 3?
Yeah, CC2, sorry, that's correct. And CC3. And CC3. CCW3, yes, ma'am.
And what do you want to tell me about them?
So, Madam Hearing Examiner, my understanding of your ruling was that these will not be admissible as evidence related to Mr. Walter's testimony.
That's right.
Okay, and then how do you propose, or how shall we deal with that in reference to where Mr. Walters references it into his deposition? Do you want us to just strike it? And the exhibits, just have strike-throughs with them, upload a new version of the corrected testimony? What's your preference, Matt?
You know, I haven't actually talked with hearing examiner Schaefer on this, so this is pending a request from Ms. Nadasi too. So I think let us think about it over the break, sir. And you know, I want the most efficient way, and if the most efficient way is just to take that out and then put some kind of footnote or reference on the cover page that just says that those exhibits weren't admitted, you know, maybe that's going to be the easiest way. But let me talk with him. So I'll just make a note that we need to give the parties guidance on this.
Okay.
All right, sir.
Thank you, ma'am. One last point. We would, at this point, make a motion for an offer of proof for both of those at this point.
Okay, very well.
Okay.
And with your offer of proof, what do you believe that the exhibits show that the testimony doesn't?
As I mentioned earlier, and I don't want to repeat, I'm not repeating myself when you're asking me, so I'm just going to quickly try to summarize it. I think that the deposition testimony has information that would help the trier of fact and the trier of law in its decision on whether this application is valid under the six-factor test. I believe that since both of those depositions were under oath and they were represented by counsel.
I don't know that. There's no affirmation. There's not even a cover page on here. So I don't have any information on these documents, Mr. Yar, other than there are select pages of what's been represented to be a deposition.
That's correct, ma'am. And as just a preliminary matter, I believe this entire deposition has been uploaded as NM exhibit 18, which is the deposition of Mr. Baudier, and exhibit.
This is hearing examiner Schaefer, Mr. Yar. I have a question. CCW1 and CCW2, are those depositions or interrogatories?
They're CCW1 are interrogatories. So to answer your first question, CCW1 are interrogatories. CCW2 is a deposition, a portion of a deposition that the witness relied on, and CCW3 likewise is a portion of the deposition that the witness relied on.
And what's your legal argument for including them as attachments or as exhibits?
As I mentioned earlier, the position we take is that these statements made by Mr. Baudier and Mr. Tumanillo were issues that were raised and relied upon in the witness's testimony, filed testimony. They are issues that are raised throughout most of the parties' concerns, and so we believe that this testimony is helpful, as any other piece of testimony or discovery would be, in helping the commission to make a determination on the validity of this In addition, I also raised that, well, I'm answering your question, hearing examiner Schaefer, and I'll stop there.
Thank you.
Mr. Yar, are you actually offering CCW2 and CCW3 as evidence of what is contained in CCW2 and 3?
I'm sorry. Let me just think about that question, ma'am. I believe the answer is yes. We are providing. We're providing excerpts of the deposition for the purpose of Mr. Our witnesses' reliance upon those statements.
Anything else you want to tell me about CCW2 and 3?
I think before I answered Mr. Schaefer's question, we were talking about the validity of these particular documents, and I was referring, Your Honor, to 2 exhibits that are currently they're in the Dropbox. I would like to be able to move those into the record and to deal with your issue relative to whether or not these are sworn statements.
And what exhibits would those be, sir?
Sure. They are exhibits 18. That's the full transcripts of the deposition of Mr. Baudier. Exhibit 23, which is the full, and this is NM area exhibits, the full testimony of Mr. Tuminillo. If it makes it easier, Your Honor, we're happy to just use the first page, or the page, the affirmation pages where he's sworn in, where the 2 witnesses are sworn in, and include them in NM area CCW 2 and 3 for just clarity purposes, rather than just throwing in the whole transcript. If that makes it easier for Your Honor.
Is there anything else you want to tell me about 18 and 23?
No, Your Honor.
Any objection to what's been identified as NM area exhibit 18, which has been represented as the deposition of Mr. Baudier?
Yes, Your Honor. This is Will Dubois.
Sir?
I don't know where we have established a foundation for using the entirety of the deposition well beyond anything that NM area claims to have had its witness rely upon, have examined the witness on in hearing, or otherwise offering a basis for admitting numerous additional pages beyond what has already been the subject of a motion to admit that has been denied. They obviously cross-examined Mr. Baudier for, I don't have the number of hours in front of me, but a number of hours, and was able to use the deposition for any impeachment or other hearing evidentiary purposes that they desired to, and to now move in an entire deposition after that, I do not believe is appropriate.
Very well. Any response, Mr. Yar?
Yes, Madam Hearing Examiner. with all respect to Mr. Dubois, I did make the clarification as an offer to try to resolve the issue that Mr. Dubois has raised, which is admitting the entire exhibit in its totality by just admitting the affirmation to address the hearing examiners. Your concern, Your Honor, whether or not CCW2 and CCW3 were under oath, and I'm reaffirming that we would withdraw our request to admit 1823 if that works for Your Honor.
Let's go ahead then and put into the record, there's been a request to admit NM Area 23, which has been represented as the full deposition of Mr. Tuminello. Any objection?
Yes, Your Honor, all of what I said as to Mr. Baudier's deposition exhibit 18, I would apply to number 23 as well.
Very well. I'll take that under advisement, Mr. Yar. Anything further?
No. Thank you, Your Honor.
Thank you very much.
Your Honor, may I very briefly be heard on the affirmation page offer?
I'm sorry, I don't know who's speaking.
This is Will Dubois.
Go ahead, Mr. Dubois, start again, please.
Mr. Dubois.
Thank you, Your Honor. Just as to that specific offer, I would just note that I do not believe addresses a number of the issues that Your Honor discussed previously in ruling on this, nor does it address the discontinuous pagination issue where we have partial answers, partial questions in a number of instances, nor does it address the preservation of objections that were lodged in there. That is all. Thank you.
Very well, Mr. Dubois. Thank you. Mr. Yar, you hear that answer? Any response?
No, Your Honor. I stand.
Okay.
Okay.
Very well. Thank you. Like I say, taken under advisement. I believe our next witness, Ms. Nanasi.
Yes, he's in the waiting room.
And I just need to go to the printer. Very well. Good afternoon, Mr. George.
Hi, good afternoon.
Welcome to New Mexico.
Thank you.
Oh, no. Ms. Nanasi?
Thank you, Your Honor. Mr. George, could you please state your name and
Moment,
spell?
please. Your Honor, may I swear the witness?
Sorry, Mr. Lee.
Lee.
Please go ahead and swear the witness.
Mr. George, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Go ahead, Ms. Nanasi.
Thank you. New Energy Economy calls Mr. George to the witness stand. Mr. George, could you please state your name and spell it for the record?
Yes, my name is Jesse George, Jesse George.
And Mr. George, did you prepare direct testimony and one exhibit, and that has been revised by the hearing examiner's orders in this case?
I did.
And do you understand that New Energy Economy has designated that exhibit as Exhibit 2?
I do.
Is it true and correct to the best of your knowledge?
It is.
If I asked you the same questions today, would you give the same answers that appear there?
I would.
Other than the additions and deletions to your testimony based on the hearing examiner's orders, is this testimony correct?
It is.
Your Honor, on behalf of New Energy Economy, I move the admission of New Energy Economy Exhibit 2. And
Any objection to what's been identified as NEE Exhibit 2, the direct
Yeah.
testimony of Mr. George
Yes,
as
Your Honor.
corrected by him here today? I think I heard a voice.
Yes, sorry, Your Honor.
that-
Rick Alvidrez on behalf of the BCP applicants. We do object. This revised version of the George testimony is still non-conforming. And specifically, if you look at well, I'll make first a general observation. This is not what I had expected. I expected that we would have seen the original version with strike-throughs, but Ms. Nanasi has chosen to redo it and renumber, repaginate and everything. But if we look at page 1 at line 19, it says, "What are your general thoughts about Bernard Capital Partners, BCP?"
I'm sorry, if we look at page and
Yes,
slow down, please.
page 1, line 19. The question is posed, what are your general thoughts about Bernard Capital Partners, BCP, close proposal to acquire New Mexico Gas Company, NMGC? That sentence does not appear anywhere in the original testimony. And then he goes on to opine, beginning at line 21. Based on my experience in the regulatory proceeding in Louisiana, I believe, one, BCP's investments in extrajudicial efforts to accomplish their business deals are problematic, and two, contrary to democratic values, and then two, BCP's overly secretive legal positions are contrary to requirements of transparency and accountability. Now, with regard to the opinion about BCP's investments in extrajudicial efforts, that was the subject of the article that you clearly struck, and Ms. Nanasi acknowledged by taking it out of the last revised version. But that was founded on the article about campaign contributions. And then, this issue of overly secretive legal positions, again, is a claim that is made with respect to the New Orleans proceeding, but this again is opinion. It's not saying this is what happened in New Orleans in the New Orleans proceeding. It's being asked to extrapolate with opinion about, well, here's what happened in New Orleans, and here's why I think this transaction should not be approved. So this does not comply with the clear ruling of the hearing examiners yet once again.
Ms. Zanasi?
yes, I believe that, first of all, Mr. Alvarez is wrong. The The question that's on page 1, line 19 was the exact question that was on page 2, line 8 from the last, from his original September 26th testimony. And I believe your honors had completely said his statements in here can only be based on his experience in the regulatory proceeding in Louisiana. Everything that's in here is only about that. And that's all that his testimony is about, other than just introducing him. And I believe that the rest could be certainly asked about how these statements relate to his experience in the regulatory proceeding in Louisiana. So I do think it complies.
Okay. Mr. Alfedris?
I do stand corrected. The question does appear, but the answer is quite different. And again, I think I've said what I had to say. I didn't see that Ms. Nanasi really countered that these are, in fact, opinions, that they don't, reflect strictly a factual account of what occurred in New Orleans, but rather they are opinions about, why the BCP applicants should not be allowed to acquire New Mexico Gas Company in New Mexico.
All right, thank you, Mr. Alvidrez. Last word, Ms. Nanasi.
Just the basically everything from line 21 down to the end was in his original, but there's things that I took out from his original, but these are based on his experience in the regulatory proceeding in Louisiana. And he can be questioned about that.
Very well. I'll take that under advisement. Anything further, Ms. Nanasi?
Just I would move to have this New Energy Economy Exhibit 2 admitted into evidence. And then I tender the witness for examination. I also will upload New Energy Economy's offer of proof number 2, the original testimony and exhibits 1 through 5 in response to the revised application.
And the purpose for that offer of proof?
Well, I have 2 offer of proofs. The original Mr. Sandberg testimony and the original Mr. George testimony, because I believe that they are important for the commission's consideration and to preserve our record on appeal, should there be an appeal. And if you want me to state the rule, the NMPRC rule that falls under, it's 1.2.2.35M regarding offers of proof.
Thank you. Very well. Any objection to what's been identified as Mr. George testimony in response to the revised application labeled as NEE Exhibit 2 as modified?
Yes, Your Honor, same objection as we registered previously.
Very well. As I indicated after hearing the argument on the specific part of the testimony, this is under advisement, and I believe, Ms. Anasi, you have passed your witness for cross-examination. Is that correct?
Yes, Your Honor.
Thank you. I do not believe, or I do believe, the only party that reserved time for cross-examination for Mr. George was BCP applicants, and 35 minutes was reserved for that. Mr. Dubois or Mr. Alvidres?
Your Honor, this is Mr. Alvidres. I'll be conducting the cross.
Very well, sir. Go ahead.
Good afternoon, Mr. George.
Hang on just one second, Mr. Alvidres. Actually, Mr. Lee, is this the appropriate time for a break? Or shall
Wouldn't
we
mind,
go
Your
in
Honor.
half-hour? Okay.
Or we
Yeah.
we can go after Mr. Alvidres if you'd like.
I'll be 10 minutes.
Okay.
So,
Okay, very well. All right, sir, go ahead.
yes. Good afternoon, Mr. George. As the hearing examiner said, welcome to New Mexico. My name is Rick Alvidres. I'm one of the attorneys for the BCP applicants. And I do have a few questions about your testimony. If I could have you look at page 2 of your testimony on line 5, do you see that?
Yes.
And just for the record, you make a reference to BCP. Can you tell us what BCP entity you're referring to there?
That would be Bernhard Capital Partners.
Is that Bernhard Capital Partners Management?
It's the applicant, the company attempting to acquire New Mexico Gas Company.
Well, what was Bernhard Capital Partners Management wasn't a party to the proceedings before the New Orleans City Council, was it?
I don't believe so.
Right. And that would have been the Delta companies, right? The Delta Utilities companies.
Correct.
So you say that BCP with Energy New Orleans LLC and Delta States Utilities prejudiced the public interest, but again, BCP was not a party to that proceeding in which you participated in New Orleans, right?
Well, as a wholly owned subsidiary of BCP, I'm referring to the representatives of Delta as BCP.
Well, isn't it true that Delta is not a subsidiary of BCP management? BCP management?
I'm not certain.
Okay. In any case, I take it you were not, your client was not satisfied with the results of the New Orleans City Council proceeding. Is that correct?
That is correct.
I take it you didn't appeal that decision, however, did you?
We did not.
And you're referring here on page 2, beginning at line 3 and all the way down to 18, about a discovery dispute that took place in the New Orleans proceeding, correct?
That's correct.
And that dispute was resolved against your client, was it not?
It was.
And you haven't been involved in the present case with regard to the confidentiality claims, isn't that correct?
Objection.
On what basis, Ms. Nanasi?
Mr. Alvidres has, on behalf of his client, has asked to strike all of Mr. George's testimony. You upheld that objection, and now he's going into whether Mr. George was involved in the confidentiality disputes in this case. I thought that the ruling was that he's not allowed to talk about this case, and he's not allowed to talk about what he did in this case, including, the interrogators he helped devise, et cetera, that was in his old testimony. So this is beyond the scope.
Mr. Alvidres?
Yes, Your Honor, the reason I asked the question is, to avoid the inference that, he really has any personal knowledge about what has happened in this case with regard to confidentiality claims. He seems to be saying, well, they were bad. They misbehaved on confidentiality claims in New Orleans, I want to show he doesn't know what happened in New Mexico. He wasn't involved in the New Mexico issues relating to confidentiality.
And Madam Hearing Examiner, I'm going to find for you exactly where he cites to the confidentiality issues in this case, but that was struck.
Well, citing to it and being involved are two different things.
No, it's not. You have moved to strike him as having nothing to do and no New Mexico experience. And on page 14 of his previous testimony, he states at line 5, this is not just my opinion. This is what BCP's attorneys argued. Quote, none of the third-party companies are or would be under common control, governance, or operations with the joint applicants. And to be clear, BCP management does not operate the third-party companies. It manages the funds that invest in the companies, which is a separate matter, and provides advice and support to the companies as appropriate. The third-party companies have their own managements running their businesses, just as NMGC's leadership would operate its business following the transaction with available advice and support from BCP management, unquote. Joint applicants' response to New Energy Economy's motion to compel and for other relief.
I'm sorry, after BCP management?
That's an end of the quote, and then it's joint applicants' response to New Energy Economy's motion to compel and for other relief at 3. So he absolutely knew about and was involved in these issues in this case, but has been forbidden for testifying about it. And now Mr. Alvidrez wants to ask about that. That's unfair.
Your Honor, he's simply paraphrasing from the joint applicant's response. I submit there is a vast difference in simply reading pleadings in a case and actually being involved in them. I mean, I would note that he doesn't recite what the disposition of that motion to compel was.
Yeah. It really appears that with the ruling that the witness can only testify to proceedings that he actually participated in,
Your Honor, I'll withdraw the question.
very well.
And I am concluding my cross-examination.
Very well. Just for the record, the objection sustained to the question. The question was then subsequently withdrawn. Very well. Good afternoon, Mr. George.
Good afternoon.
How are you today?
I'm doing fine, thank you.
Great. I see that you're a lifelong resident of South Louisiana. Is that correct?
It is.
And you're here today to help provide information to the commission as your education and your experience as a legal representative. You're an attorney, and who is your current employer?
I work for the Alliance for Affordable Energy.
And that's given a New Orleans address.
That is correct.
And is this a nonprofit organization, or is this tell me about the Alliance for Affordable Energy?
Yes, we're a nonprofit utility regulatory watchdog organization.
And you have been employed for a few years with them. Is that correct?
In my current tenure with the organization since 2021, I also worked with the organization between the years 2008 and 2010.
And you have indicated that you have had personal representational experience with BCP or its affiliates. Is that correct?
That is correct.
And what type of, you indicate in your testimony on page 2, and in response to Mr. Alvidra's questions, that this was a proceeding with a BCP affiliate before the city of New Orleans. Is that correct?
That is correct.
And that was, the affiliate was Entergy and Delta States Utilities, or just tell me a little bit about that. Was it both?
No, the BCP affiliate is Delta Utilities. Entergy was previously both our electric and gas utility, and they filed a joint application along with Delta Utilities for the sale of the gas system.
And so that had to be approved by the city of New Orleans?
It did. Under our home rule charter, our city council has regulatory authority over utilities in Orleans Parish.
And approximately what size entity is Delta States Utilities?
I believe they have somewhere in the range of 100,000 gas customers, something like that.
And are these formal proceedings? I mean, are there applications and pleadings, and are they assigned to hearings, and is there discovery?
Yes.
Tell me about what kind of proceedings happen before, is it the City Council of New Orleans?
It is. They are formally docketed proceedings. The council sets out a procedural schedule, appoints a hearing officer to preside over the docket. The hearing officer makes only rulings on procedural matters. They do not make substantive rulings. That is left to the council.
And are there hearings?
Not regularly. Typically, we rely on paper filings, and then we have occasional technical conferences. Very rarely are there in-person hearings.
Do you submit evidence?
We do.
Like in cases here with our Public Utility Commission, where you actually submit pre-filed testimony?
Correct.
And so in this particular proceeding, you represented Alliance for Affordable Energy as an intervener in the application for acquisition,
That is correct.
and you took a position adverse to having the acquisition application approved?
We did.
And did you, on behalf of your client, submit testimony?
We did.
And were there other interveners in this proceeding?
There were.
And could they be characterized as supporting or being in opposition to the approval of the acquisition?
I would say it was a mix.
And what was the basis of the testimony that you presented on behalf of AAE, um, what supported your position?
Well, our council has a standing order that lays out 18 factors that it must consider when approving deals of this kind. And so we had our expert take a look at those factors and apply them to that proceeding, and that was the basis of his testimony. Ultimately, you know, to sum up the requirements of those 18 factors, among other things, they require a showing of both short and long-term benefits to ratepayers, and we argued that neither was proven in this case.
Approximately how long, well, before I get to that, you claim in your testimony that that Delta States acted against the public interest by utilizing a practice of over designating certain discovery materials as what you define in your testimony as a confidential designation above the highly sensitive protected materials that you characterize as one that they invented to hide their financial maneuvers, and one which has no basis in the New Orleans City Council standing protective order for utility proceedings. That's your testimony, sir, correct?
That is correct.
Well, tell me a little bit about how this standing protective order works in your proceeding.
Sure. So our council once again has a standing order regarding, confidentiality in utility regulatory proceedings. That order provides for a designation of highly sensitive protected materials, which can then only be provided to interveners who have signed a non-disclosure agreement or confidentiality agreement. The order does provide for designations of confidentiality above that designation, but only with council approval. In this proceeding, Delta Bernhard did not seek that prior council approval and designated of its own, volition all the certain materials as what they designated highly sensitive protected materials dash commercially sensitive. These materials they provided only to the council's utility advisors and to no other parties in the proceeding.
So none of the interveners got the documents?
That's correct, aside from the council's utility advisors.
And I'm assuming that you and the other interveners attempted to get access to the documents?
We did. We filed a motion to compel with the hearing officer, or in the alternative to make the reasonable accommodation. It just so happens that the expert that we were relying on in this case happens to reside in Denver, Colorado, where the council's technical utility advisors also are located. So in the alternative to compelling production of those documents, we asked the hearing officer to order Bernhard/Delta to allow our expert to review those documents in camera in the utility advisor's office in Denver. Bernhard opposed that reasonable accommodation and insisted that our expert had to be flown to New Orleans from Denver to view those documents in their offices. despite the fact that they had been provided to the council's advisors in Denver.
Did your expert eventually, whether in Denver or in New Orleans, get access to the documents?
No, we did not have the budget to fly him to New Orleans to review those documents. Unfortunately, we're a small organization and we have to allocate our resources judiciously.
Did any of the other interveners get to see the documents?
Not to my knowledge.
And then did you conduct discovery in this case before the council?
We did.
And then what happens after you have had the opportunity to conduct discovery and present testimony?
Then the hearing officer certifies the record. The council's utility advisors file their report and recommendations to the council, and the council makes a decision.
Is there an opportunity to object or file some alternative? Do the parties to the application get a copy of the report
Of the
from the council advisors?
Yes.
And then do you have an opportunity to like file exceptions or to object to what happens in the report or comment on it or?
No, the only opportunity for comment is the day that the council votes. There is opportunity for public comment, as at all council meetings. It's limited to 2 minutes per person. And that's the only comment allowed after the council advisor's report is filed.
So if you're a party to the application proceeding, are you allowed to come and give public comment?
Yes,
Did you do that on behalf of AAE?
we did. In fact, we turned out scores of people, both in person and online, commenting in opposition to the sale.
And then what was the result of the council vote?
The council voted the week before Christmas last year unanimously to approve the sale.
And how many people are on the council?
7.
Did you have any other interaction with BCP in this particular or BCP affiliates? Delta Utilities? Did you have any other non-confidential interaction with them during this proceeding? That you want the commission to know about?
No, my only interaction with them was through the formal proceeding before the council.
Okay. All right, sir. And this proceeding in front of the New Orleans Council is your only formal proceeding, at least so far, that you have interacted with what's been referred to as the BCP joint applicants or their affiliates in Louisiana or Is that correct?
That's correct. They previously were not operating any public utilities in Louisiana.
All right, sir. Thank you. I think that's all the questions I have for you. Hearing examiner Schaefer, any questions for Mr. George?
No, thank you.
Very well. Ms. Nanasi, any redirect of Mr. George based upon Mr. Alvidra's cross or my questions?
No, thank you, Your Honor. I just want to thank Mr. George and again move New Energy Economies Exhibit 2 into evidence.
Very well. Mr. Alvidras, any questions based on my questions for Mr. George?
No, Your Honor, and to the extent I need to respond yet again to the motion to admit, we do object for the reasons stated.
I think the ruling was that he could give his opinion based on his experience in the regulatory proceeding in Louisiana. I think I've asked him about that that proceeding. I think he's explained how the proceeding was conducted and why. So I think with regard to your objection, Mr. Alvidras, you know, I think, you know, I think line 1, number 2, I think he can make that conclusion based upon his participation. You know, I do agree that the opinion in number 1 on line 21 and 22 are not responsive to that to the order, and he hasn't told me anything about the procedure. You know, except his qualification of, you know, offering the discovery alternative. I don't know that that's necessarily an investment. That's a behavior. So I think, you know, I would strike lines 21 and 22 to the extent he's opining on extrajudicial efforts that weren't he didn't testify to. So that opinion I'm not going to consider, and it goes on to the first 4 words of line 21. But number 2, like I said, I think that's perfectly appropriate based on his testimony. So I'm going to admit NEE Exhibit 2 as corrected, except for page 1, number 1, as it carries on. Otherwise, NEE Exhibit 2 is admitted. Ms. Nanasi, anything further?
Just a quick question. Do you want me to just strike through that and then resubmit it? Do you want me to just take that out? Do you want just, okay, it's just as is. Okay, thank you so much.
Yeah, I'm just gonna note that the that particular part that I struck is not admitted, but the rest of the exhibit is. So yeah, just so we're clear, why don't you just submit it again and just strike through that? Strike through the part that I'm striking and
I'll do that.
okay. And Mr. George, thank you again very much for your time, sir. You're excused.
Thank you.
Okay, I think we are anything further from NEE, Ms. Nanasi?
No, I'll just wait to, I'll put that into Dropbox and remove that. Did you say strike through or remove?
Just strike through it.
Okay.
I think that seems to be from what I looked at yesterday and what the position, for example, with the NM area witness, just the red strike throughs,
Okay, I will do that.
That way
and then
everybody knows what comes out, what goes in.
Okay, and yeah, and then yes, and I would like to just, once you determine how you want me to address the whole exhibit issue with Mr. Sandberg, then I will abide accordingly.
Very well. I appreciate that. Thank you. All right, we are 3:25. Let's take a 10-minute recess at this point until 3:35. And then I believe that the next witness, I believe, Ms. Beatles is your witness?
Yes.
Okay. Mr. Sabukel?
Yes.
Okay. We'll hear from him.
Great.
All right, we are recessed for 10 minutes. Please make sure you realize YouTube is on. Very well. We are returning from our afternoon recess. Mr. Lee, are we ready to go?
Yes, sir. Yes, ma'am.
Very well. Ms. Beatles, you have a witness.
Yes, I do, and I see that he has been admitted. So Western Resource Advocates calls Bradley T. Sabulko.
Good afternoon, Mr. Sabulko. Welcome.
Thank you. Good afternoon.
Mr. Lee, would you please swear the witness?
Mr. Sabulka, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Thank you.
Mr. Sabulko, for the record, could you please state your name, firm, and address?
Sure. My name is Bradley Thomas Sabulko. I'm a partner at Current Energy Group, and our address is 2900 East Broadway Boulevard, Suite 100, number 780, Tucson, Arizona, 85716.
Thank you. And do you have before you a copy of your corrected revised direct testimony filed on September 26, 2025 in this docket, and that we have marked as WRA Exhibit 2?
Yes, I do.
And this is the public or redacted version of that testimony, correct?
That's correct.
Do you have any changes other than those ones that were marked and explained in the errata dated October 20th?
I do not.
If you were to answer today the same questions contained in WRA Exhibit 2, would your answers be the same?
Yes, I would be.
And are they true and correct to the best of your knowledge and belief?
Yes.
I move the admission of WRA Exhibit 2.
Is there any objection to what has been identified as WRA Exhibit 1? Mr. Sabulko's pre-filed testimony as affirmed by him here today.
Madam Hearing Examiner, I believe you said WRA Exhibit 1, and we have marked this as WRA 2, and Mr. Kenny's is marked as 1.
I apologize. WRA Exhibit 2, the corrected revised direct testimony of Mr. Sabulko. Hearing no objections, WRA Exhibit 2 is admitted.
Thank you. I pass the witness for cross-examination and questions from the bench.
Is there a WRA confidential?
Yes, there is. Do you want us to move the admission of that too? I don't often deal with confidential testimony, so I wasn't sure what you want to do with that.
Well, we all know it exists, and I think for admittance into the record purposes, we need to admit it. if that is your intention, Ms. Beatles.
Yes, understood. Thank you. Let me just make sure that I have the proper exhibit number. And yes, that was served on all parties who had completed a confidentiality agreement and on yourselves, the hearing examiners, and submitted to records. So that is, wait, I'm sorry. Yes, okay, so Mr. Cebulko, and you have reviewed the confidential version of your direct testimony that we have labeled as WRA Exhibit 3, correct?
Yes.
And do you have any changes or corrections to that testimony?
No, I do not.
And if you were to answer today the same questions, which are essentially the same, but they contain confidential and protected information, if you were to answer today those same questions, would your answers be the same?
Yes.
And they're true and correct to the best of your knowledge and belief, correct?
Correct.
Okay, I move the admission of WRA Exhibit 3, which is the confidential version of Mr. Cebulko's corrected revised direct testimony.
Mr. Cebulko, was there any attachment to your confidential version of your testimony?
Any attachment? Well, there would be the exhibits. Are you speaking to something else?
No. So basically, the only difference between your confidential revised direct testimony and your regular is that in places in your regular testimony where you have left out something because it is purportedly confidential, you have filled it in on the confidential version. Is that right?
Yes.
Okay.
And Madam Hearing Examiner, I believe there are at least a couple of confidential exhibits that were attached only to the confidential version.
Okay, that was my question. And you say there were some confidential exhibits that were attached in addition to the regular exhibits?
Yes. I don't know if you want Mr. Cebulko to answer that, but looking at his exhibit list, I do see that there was at least one that was excluded from the public testimony with the one that was excluded from the public testimony and 1, 2, 3 others that were the redacted versions were attached to the public and the unredacted versions would be attached to the confidential.
Mr. Cebulko, is there any attachment to your confidential testimony that was not included in your public version?
I apologize for the mistake earlier. So I believe it's exhibit BTC 24 confidential J exhibit NMDOJ 3-1.
So the answer is yes?
Yes, that'd be correct.
Any others?
The only other place where I referenced confidential testimony would be on pages 12 or not, sorry, confidential information. We on pages 12 and 13 of my testimony. Which reference Exhibit BTC 3, JA confidential response to WRA 3-1.
Okay, still trying to understand your confidential testimony. Do you have any exhibits in your confidential testimony that are not included in the public version?
I would believe that it would be just NM DOJ 3-1, that's exhibit BTC 24.
Very well. Any objection to what's been identified as CCAE exhibit CCAE WRA exhibit 3, the confidential corrected revised direct testimony of Mr. Sabuco as affirmed by him here today. This is confidential testimony and it has been provided to the parties who have signed confidentiality agreements and to the hearing examiners and to records, but is not publicly available. Hearing no objection, WRA Exhibit 3 is admitted. Just an instruction to the participants, if anyone happens to want to ask questions on WRA Exhibit 3, please notify me ahead of time because we will have to make special arrangements to have that occur. Ms. Beatles.
Yes, I now pass the witness for cross-examination and questions from the bench.
Thank you very much. I believe that gas company has reserved 20 minutes for Mr. Sabuco. I see you leaning in there, Mr. Dome. Is this your witness?
Yes, it is, Madam Hearing Examiner.
All right, go ahead, sir.
Very well. Good afternoon, Mr. Sabuco. How are you?
I'm all right, thank you. How are you?
Fine. I'm Tom Domi, and I'm the attorney for Emera and the gas company in this case. So I'm going to try to stay in my lane and ask you questions, kind of focus primarily on Emera and the gas company. I might trickle over a little bit into BCP things, but I think the next council will ask you more about BCP. All right?
Very well.
So I want to start, and I'm going to start a little bit with your resume and so forth. So on your resume, I see that you got a Master's of Public Administration up in Washington, at Seattle University of Washington, correct?
That's correct.
What is the gist of that kind of a program? I'm not familiar with what a Master's of Public Administration really deals with.
It's a professional school, Masters of Public Policy, Public Administration, Public Management, has a variety of different names. The course load is, think of it somewhat like an MBA for public service. So a lot of finance, economics, management type classes. I think that's a good summary.
Okay. What was your concentration in at that program?
Tend to be more in the environmental management side.
Were there various areas that you could go into?
I'm sorry?
Were there various areas that you could concentrate into?
Yes,
And you chose the environmental policy areas.
that's correct.
Was there a utility area that you could focus in?
Not at the time.
Did you take finance classes or accounting classes when you were going to what's the name of the school? What's the name of the school?
The Daniel J. Evans School of Public Policy and Governance, I believe is the official name now, something to that effect. And your question, sir?
Were there finance concentrations or finance areas you could have gone into?
I took I think as a part of the core curriculum, if I remember correctly, as a public finance class. I believe you may have been able to concentrate in public finance.
What is the difference between public finance and finance?
I think it's mostly focused on the administration of governmental entities.
Did you take any strictly business finance classes?
I don't believe I did.
Okay, thank you. How about accounting? Any accounting classes?
I don't believe I did. I don't recall if there was an accounting class as part of the core curriculum, but I certainly would not have taken any more other than what was there required.
I took one and then went into finance, so I know what you mean. You are the founding partner of Current Energy Group, correct?
I'm one of 5 founding partners.
Okay. And what is the focus of Current Energy Group?
We are a regulatory consulting firm. We work with clients across the country, primarily on electric and natural gas regulatory proceedings.
And have you divided the firm up a little bit and specialize in any particular areas, the 5 of you?
Sure, we have. There's some overlap. I tend to work on gas utility issues as well as electric and gas issues. We're closer to home where I'm located in Washington State.
Okay. You also said that you were the founder of CEB Energy Consulting, and that lasted from March until May. Tell me a little bit about that.
I left my previous firm, Strategy Consulting. I started a sole proprietorship.
I'm sorry, I left my previous firm.
My previous firm, Strategy Consulting. I set up my own sole proprietorship that lasted a few months, worked with some clients, and then started Current Energy Group with my current partners.
And was CEB kind of with the same focus as Current Energy, but you just brought in additional partners?
Well, it was me by myself for a period of time. But the nature of the work was similar, is similar.
And then I see that you worked for the Washington Utilities and Transportation Commission from about 2013 up to 2021. Is that correct?
That is correct.
And what was your focus with them?
So the first 3 years as a regulatory analyst, which is the structure of the Washington Utilities and Transportation Commission is that there is a staff and an ex parte wall from the commissioners.
I'm sorry, there is a staff, and please slow down.
Thank you, and my apologies, sir. There is a regulatory staff that serves as an independent analysis group that during adjudicated proceedings participates before the commission. There is an ex parte wall between the commissioners and the staff. I was in the Integrated Resource Planning and Energy Efficiency Group for 3 years. After that, I was asked by the commissioners to be an advisor, an energy policy advisor to the commissioners, where I spent 5 years.
I would like to turn, if I could, to page 15 of your testimony. That would be WRA Exhibit 2, not the confidential version, the non-confidential version.
I'm there.
And you indicate on lines 11 through 14 that in response to the question about the premium, as you use that word, is non-recourse, which means they will not seek to recover the cost from customers. And then you ask yourself, please explain why this commitment does not sufficiently protect customers. Do you see that question?
I do.
And your answer is, I am concerned that they will seek to recover it indirectly. And then at the bottom of that page, you say there are 3 ways to do that. Cut operating costs, seek an increased return on equity, or accelerate growth of NMGC's rate base. Do you see that?
I'm sorry, accelerate growth of?
NMGC's rate base.
Thank you.
And it's that third area that I want to focus on. So explain to me what you mean by accelerate the growth of NMGC's rate base as a means to indirectly recover this premium.
Certainly. So, as I explained in my testimony, the revenue requirement, right, is built off of the rate base times the rate of return, and then operating and O&M costs, taxes, depreciation, expense. And the value to the company is either to extract dividends to the ownership, it's either extract dividends, or it is to grow the company, that its net book value and its overall value increases, thereby when they sell the company in 12 to 15 years, that the ownership has made a healthy return.
And that's what you described that later on about how that's how they're going to grow their rate base. That's what you're talking about, correct?
I said that is my concern, is that relative to the status quo, that the evidence shows that that is the likely pathway based on what BCP applicants have put forward, that that is an outcome that will likely happen or they will pursue.
Right. Do you believe that New Mexico Gas Company will try to grow its rate base over the next 12 to 15 years?
My analysis of what was put forth in this record was that NMGC, under Emera's ownership, is forecasting a growth in its rate base.
And you, on page, I guess it's page 25, around page lines 12, 13, 14, you indicate that New Mexico Gas Company has been growing its rate base greater than its growth rate from its customers. Is that correct?
Excuse me, I'm going to read for a minute if you don't mind.
Please do, yes, please do.
Yes, in here I testify that NMGC's historic from, was it 2016 to 2024, annual capital expenditures grew at an average annual rate of 9.44%, which was 2.5 times greater than its growth in system-wide, non-weather adjusted annual demand.
I'm sorry, what adjusted?
Non-weather adjusted.
And you state there that, well, let me ask you this. Did you find any testimony in this case where New Mexico Gas Company said that customer demand growth was what was driving their rate base increase from 2016 to 2024?
No, I don't recall any. My analysis comes from, let's see, what was this? A response, discovery response. I recall seeing actually specific, I think NEE had asked for actual capital expenditures over that period of time.
Okay. Yeah, and so I guess I'm trying to understand what you're doing here. So the first thing you do is you eliminate growth as the basis for increased rate base going forward, is what I understand you're doing. Is that correct?
No.
Objection. I was going to say that mischaracterizes his testimony, but I think he beat me to it.
He beat you to it, yes. Go ahead, then explain to me what's wrong with my question.
I'm sorry, will you please repeat your question?
Yeah, I'm trying to understand what you're doing here, and I thought what you were doing was you were eliminating customer growth as the rationale for NMGC expanding its rate base in the foreseeable future.
So this area that you've highlighted, I'm explaining what has happened in the recent past from 2016 to 2024. And I am saying that NMGC's annual CapEx growth is growing much faster than its annual demand. This has important affordability implications. But I am not using this data right here to identify my concern about the acquisition, right? That gets into, and I will not discuss the confidential information, but that discussion happens later on page 30, which does get into confidential information.
Right, and the version that I'm looking at on page 30, the confidential information on that table is blacked out, is it not?
That is correct.
And as I understand what you're doing with that table is you're saying you've got 3 rows here. We're not going to get into the numbers. You're saying that the BC applicant's growth rate is whatever it is. And I'm sorry, the Emera growth rate is whatever those numbers are. The BCP applicant's growth rate is the next line of numbers. And you're saying that the BCP proposed growth rate is higher than the NMGC Emera growth rate. Is that correct?
Yes, during that period of time that I am identifying.
Over the next 10 years. Do you, and the question I'm trying to get to is, do you find anything wrong with NMGC's growth rate between 2026 and 2035?
I did not conduct an analysis of their capital expenditures from 2016 to 2024. That was not the purpose of that testimony.
Okay.
The purpose of the testimony was to identify a trend.
In fact, going back to pages 28 and 29, you make a point out of the fact that New Mexico's gas company, I'm on page 28, line 13, that New Mexico's gas system is relatively new and not leaky, is your testimony correct?
Yes, as I say, NMGC system is relatively new and not leaky as compared to its peers.
Right.
The rest of the paragraph explains it as compared to its peers.
And on page 29, you go on and you refer to BTC 8, the Black and Beach report, and in that question that starts on line 3 and goes down to the end of the page, subparagraphs A, B, C, D, and E, you essentially praise the gas company system. Is that correct? That's a paraphrase, I know it, but all right. You say that the material composition is in line with industry standards. The average number of leaks is well below the national average. The leaks has declined from 2015 to 2023. The hazardous leaks is significantly below national average, and the number of corrosion and hazardous corrosion leaks has remained steady and significantly lower than the national average. That's the summary of those 6 points, isn't it?
Well, to clarify, I didn't say that. I'm quoting a report that said that.
But you put that report in your testimony.
Yes, I did. And I think this is important, right? For the context that we talked about later on page 30, confidential information that which we will not discuss numbers, but to underlie that the company's system is relatively new and not very risky. I work in a lot of states with cast iron and bare steel, relatively risky pipe. And I am not seeing, based on this, that there is a high level of need for accelerated growth, right? This is not to say any prudence determination about any specific investment. But my point is then when I then look at what BCP's forecast is, it raises my attention.
So on that point, and I don't want to get into the confidential material, so we're not going to talk numbers here.
Okay.
But I will tell you tell me, how did you calculate that table on page, how did you populate those 2 rows on page 30? Don't give me the numbers, but how did you populate that table?
Well, as you can see, looking at the WRA exhibit number 2, which is the public version, there are 2 citations, 62 and 63, that reference exhibits.
Right.
And I took those numbers from those exhibits.
I will tell you, Mr. Sabuco, when I looked at the numbers, and we're not going to talk about the numbers, but when I looked at those, I saw that the row that you took the numbers from for the Amera line was the 13-month average numbers for Amera. And the row that you took for the BCP applicants was the end of the year information. Was that a mistake on your part, or did you do that on purpose for any reason?
I am not. This is the first that the company has raised this issue.
If that's true, and I think the documents speak for themselves, if that's true, wouldn't that exaggerate the difference between the Amera numbers based on a 13-month average and the BCP applicants numbers based at the end of the term numbers?
Can you just, what do you mean by end of term?
Well, the end of the year.
The end of the year versus a 13-month average.
Right.
I would have to look at the documents before me to give you an answer.
And I'm not going to have the time for us to do that here. I just wanted to point out
Objection, counsel is testifying or about to.
No, counsel was stopping.
You got 1 minute, Mr. Domingue.
Madam Hearing Examiner, could I borrow 5 minutes from another one of my witnesses?
Okay,
I'd like to borrow 5 from staff witness Tupler.
okay. Go ahead, sir.
So Mr. Sabuco, you indicate in your testimony, you refer to BTC 8, do you not? That's the Black and Veatch report.
Yes, I referenced the Black and Veatch report.
So could you turn to, well, let me ask you this. Do you know what an integrity management program is?
I've reviewed distribution integrity management plans. Yes.
I'm sorry.
I didn't get the first words either, Mr. Brett. Could you say that again, please?
And let me get up. Yes, I have reviewed utility distribution integrity management plans.
Okay. Is it you're under, let me turn to page 66 and 67 of 73 in exhibit BTC-8, if you could, please.
I'm at BTC 8. Can you give me the page numbers again, please?
Yes, 66 and 67. And I want to look at table 5-2 and table 5-3. That's too many numbers. So let's start with pages 66 and 67.
I apologize, but you are in BTC-8?
Yes, I am.
Thank you.
And this is page 66 of 73.
Yes, yes. and page and table 5-2 on that page.
I'm there.
So that table talks about historical pipeline replacement CapEx 2019 through 2023, correct?
That is what table 5.2 says.
And you see on the left-hand column, MAOP replace, PVC, DCX Trube, TRUBE, and so on down that column, correct?
Yes.
What do you understand IM to be referring to?
Integrity management is my guess, but I don't know without being certain.
But you've dealt with these kind of plans before, so that is what you think it applies to?
Now I'm just speculating, but yes, that's based on our conversation.
Okay, does MAOP replace have anything to do with integrity management?
MAOP stands for maximum allowed operating pressure. I'm not, perhaps this is referencing to transmission pipes where PHMSA has a reconfirmation, MAOP reconfirmation process for utilities. So.
And I understand you're not an engineer, but you have dealt with integrity management programs. As you look at table 5-2, do you understand that to indicate that the company, New Mexico Gas Company, has spent $82 million on integrity management between 2019 and 2023?
Not quite 82 million, but yes.
Yeah, you're right. $81,866,329.75. Please look at table 5-3 on page 67. You see that table?
I do.
And you see that that's a projection for 2025 through 2034, correct? Table 5-3.
Yeah, sorry, I'm just giving context.
That's fine. That's fine. So table
yeah, so table 5.3 says forecast pipeline replacement CapEx 2025-2034.
I mean, I understand you're in context, but you looked at this document when you prepared your testimony, correct?
Yes.
And so table 5.3 indicates that the projection for IMMAOP and so forth, it mimics table 5.2 that we were just looking at, totals something in the range of $406 million over the next 10 years, correct?
That appears to be correct.
And that is money that was projected to be spent by New Mexico Gas Company well before the testimony was prepared in this case, correct?
My recollection was this was a report produced in advance of the acquisition.
Thank you. Madam Examiner.
You're out again. Yes,
I
sir.
know I am, but I've got more in reserve, ma'am. May I borrow 5 minutes from Zigich, please?
All right, go ahead.
Mr. Sabulko, your testimony picks up on page 53, and I'd like to talk to you about page 53 going forward.
I'm sorry, we're leaving this
Yes,
BTC.
no, we're leaving BTC 6-8.
And what page was that?
53 of your testimony.
I'm there.
This is, you've labeled this as recommendations and conditions, correct?
That's correct.
And you start this off by saying, for the reasons discussed in my testimony, I recommend that the commission reject the proposed acquisition. And then you go on and now you're going to propose some recommendations and conditions, correct?
I believe I say my primary recommendation is to reject the acquisition. However, should the commission move forward, yes, I propose some conditions.
And the first one I see is on page 54, starting at line 10. You recommend at line 11 that the commission require NMGC to the extent practical to comply with rules applicable to a registrant under the New York Stock Exchange corporate governance standards. Correct?
That's
and
correct.
then for the next page and a half, all the way down to the top of page 56 at line 8, you list, as I understand it, reports and filings, financial filings that you recommend New Mexico Gas Company be required to file with the NMPRC. Is that correct?
I think I'm not entirely, I don't entirely agree with your characterization. Some of this would be reports, financial reports and public disclosures. Others are discuss, how the company engages auditors, more policies and practices. So I wouldn't characterize each of these as requiring a report.
Okay, I'll accept that. But there are recommendations for actions to be taken by the gas company that you're recommending happen if this transaction is approved, correct?
Yes.
Did you do any cost analysis of what such requirements on New Mexico Gas Company would cost a company like New Mexico Gas Company?
I did not.
Did that concern you at all?
Did what concern me?
That what the cost of these recommendations would be to the gas company?
Yeah, I think cost is relevant, but it also needs to be in proportion to the risk and other costs and benefits that could possibly be incurred. I think as I put in here, this was a condition. These were conditions I saw in another utility acquisition case and were agreed to by the utility.
Yeah. And I'm out of time again. You also recommended changes to the IRP rules. What authority did you cite to support changes to the IRP rules as part of this proceeding?
Excuse me, can you point to where I discuss IRP?
Yes, on page 56, line 16.
Let me pose an objection just by use of it's ambiguous, by use of the word authority. Are you asking for his bases as a regulatory expert, or are you asking for legal authority?
I'm asking for the first because he's not a lawyer, so I would ask for the first.
And I'm sorry for not running that objection through the hearing examiner. I apologize.
I apologize for answering without the hearing examiner.
Apology accepted.
Well, do you have what regulatory authority do you cite for making changes to the IRP rule in this proceeding?
I don't believe I've identified a specific rule that would be modified. It's my experience that the commissions typically have wide latitude over the requirements of integrated resource plans, and that I was focused on the type of information that would be helpful and beneficial to the commission for mitigating the risk to customers that I identified in my testimony.
Before I get in trouble, I'm going to ask you one last question, and that is, even if New Mexico Gas Company was to do the financial filings and the IRP recommendation you make and the greenhouse gas emission changes that you suggest, you still would not recommend approval of this transaction. Isn't that correct?
Objection. It calls for, well, it's ambiguous insofar as you referred to emissions related objections, and I'm not sure specifically. It's unclear what specifically the council is referring to.
Mr. Domick?
Well, I'm referring to the next recommendation, which is that that NMGC through its regular integrated resource plan demonstrate how it will reduce emissions in support of New Mexico's greenhouse gas emissions. I ran out of time to go into that one in detail, so I just kind of lumped it in there at the very end.
I withdraw my objection.
So the question
Answer
was,
the question. The question was, even if New Mexico Gas Company, I guess, agreed with what you wanted on pages 54 through 58, you still wouldn't recommend that the commission approve the acquisition.
thank you, hearing examiner. Based on the record before us today, I have not seen the company, and I will answer your question. I have not seen the company wrestle with my concerns, primarily related to the net benefits associated and the long-term risk, both short and long-term risks to customers. And so, no, at this time, I would not recommend the commission approve this acquisition.
That's all I have, Madam Examiner. Thank you for
Mr.
indulging me with a few minutes.
I believe that BCP applicants have reserved 40 minutes. And Mr. Dubois, is that you?
That is, Your Honor. Thank you.
Go ahead, sir.
Thank you. Hello, Mr. Cebulko.
Hello.
I'm Will Dubois, and I'll be asking you some questions on behalf of the BCP applicants. First, could you please take a look at page 2 of your testimony? And the question, what is the purpose of your direct testimony?
Yes.
Was your assignment in this case an open-ended one to review the original application and testimonies, revised application and testimonies, and make your own judgments as to what among them you were going to respond to?
Yeah, to the best I understand your question, when I engage with my clients, we talked about the case and they asked me to review it and to identify what I thought about the case.
And you state that you provide the commission a recommendation on the application, correct?
I'm sorry, and you state?
That you provide the commission a recommendation on the application, correct?
Yes.
And do you make that recommendation from the perspective of how you believe a commissioner or hearing examiner would review the record in the case?
Yeah, my experience is as an advisor to the commissioners, and from the perspective of a commissioner making a decision about what is in the public interest. That's my experience. That's my career so far, and that's the lens I brought here.
Did you review the complete record in this case?
By complete, you mean every document that was filed?
Yes.
No.
Could you please, a question first to make sure we're on the same page on exhibits. If I point you to material in your exhibits, will it be easier for me to give you a page of the PDF file or pages of, or identify which exhibit within your testimony and the page of that exhibit?
First, I really appreciate that you asked that question. That's kind of you. I think a PDF page, assuming that our PDFs are the same, would be my preference. So let's try that and then go from there.
All right. Thank you. I'll try not to hold it against you that you accused me of being kind. I don't know what to. If you could go to page 8 of your testimony, please. And the question and answer with the question beginning on line 11 of page 8.
I'm there.
Can you please explain to me what relationship you see there as being between the quote $250 million in private debt, end quote, and the response you provide to the question?
Yeah, that's a pretty, now upon reflection, I probably would not ask and answer that question the same way. I would focus on the answer there, which is to provide kind of stage setting for what this case is about and the price that the BCP applicants are paying.
Okay. Is the question sort of disconnected from the answer?
Yes.
Then? Okay. Could you please provide your definition of goodwill as you use it in this response?
Sure. My understanding of goodwill is it's the same as premium acquisition, which is the price that is, it's the difference between the price that is paid and the net book value of the company.
Is it your understanding that they are synonymous, or that acquisition premium is a way of measuring goodwill?
The latter.
Okay. And you are aware that NMGC has had $408 million of goodwill on its books as recently as in 2024 under Emera ownership, correct?
I don't have the number off the top of my head, but I will, subject to check, agree to what you're saying.
You would agree that Emera, you would agree that NMGC has had goodwill on its books prior to anything related to this transaction, correct?
Correct.
And is it your opinion that Emera took steps to require NMGC to cut costs, overinvest, or seek inappropriately high returns on equity in order to make up for that amount of goodwill?
Are you referencing a specific section of my testimony?
Are you able to answer the question if I don't?
I don't recall. I have not reviewed Emera's history of CapEx investments, O&M investments, to give an answer to whether they were reasonable or not. That's not something I did in the course of this case.
Do you believe they were incentivized to do all of those things throughout their ownership?
I think that the regulatory construct incentivizes, has a capital expenditure bias, inherent to it. But I have not looked at the previous, tenure of Emera's ownership to answer your question.
So let's go to page 15 of your testimony, then beginning at line 17.
Yes, I'm there.
And this is a passage you'd already discussed, beginning, stating to generate a reasonable return, they, being the BCP applicants, will have strong incentives too. And then you list 3 things there, correct?
That's correct.
In your opinion, do all utilities have incentives to do those 3 things?
Well, to an extent, but it depends on the circumstances, the magnitude, right? There is a difference between this case and Emera's acquisition. And my understanding is, well, I can say for certain that the BC applicants, the infrastructure funds will expire after 12, 15 years. It's close-ended. That was not my understanding is that's not the case with Emera. And so I think there is a difference in the incentives and that and the gas utility owner will feel depending on their kind of their strategy, right? And their desire to hold a utility.
And you believe that Emera had an incentive or had a desire to hold New Mexico Gas Company for a period longer than 10 years?
I don't know Emera's desire. I just know what was, what I saw in the case, and I did not see, a close-ended situation like I do in this case.
You could go actually to page 15, lines 4 to 5 of your testimony, please.
So same page, just lines 4 to 5.
Yes, please.
Yes.
And you use the phrase there, quote, short period of time, end quote. And I believe you use the same or similar phrases elsewhere in your testimony. Could you please define what you mean by short period of time?
Sure. In this case, short period of time would be the minimum of 10, maximum of 15 years that BCP applicants intend to hold NMGC. And I say short term, short period, which is relative to customers in this case, who have a much longer outlook.
Do you know how long the average customer is a customer of NMGC?
I do not know that answer, but typically in these situations, we think of customers' interest being generational, right? 30 years longer, because they tend to be captive customers with few options or alternatives.
Is it your opinion that a utility owner is incentivized to maintain the utility's value, even if it would intend to sell it at some point?
Yes.
Did you review the materials that you provide as exhibits to your testimony with an eye toward forming an opinion about Emera's intention as to further holding NMGC if this transaction is not approved?
So if I understand correctly, your question is, when reviewing the documents, the exhibits I included, did I examine whether what Emera would do if they held the company? Is that
Yeah.
the uh I would certainly be interested in that. And so my expectation is that that's how I reviewed the documents at the time. Um, but nothing is jumping out right now, just scanning my memory.
Did you, in performing your analysis and presenting an opinion, consider Emera's stated reasons for selling
Mhm.
NMC?
Yes, I did.
Could you please explain how you weighed that?
Sure. And I believe I discussed this on page 52 of my testimony. And sorry, do you mind if I just take a minute to reread it because I want to make sure I'm characterizing my testimony correctly? Right. So as I recall, and I'm reading here in my testimony, uh, there was material that I read in which Emera said is pursuing the sale of two companies, the hope that one would be successful. I recall that the Labrador Island link, I believe they described as the most important and impactful sale, which I believe went through. And they wrote, I write here, Emera continued that would only pursue the sale of New Mexico Gas Company on, quote, terms essentially neutral or positively impactful to shareholder value.
Could you please go to one of your exhibits? It would be page 96 of the PDF. It is exhibit BTC-6. It's part of BTC-6.
Does it say transaction rationale?
Yes, it does.
Transaction rationale?
Correct.
Thank you.
And this discusses Emera's transaction rationale on a standalone basis without regard to Labrador, correct?
It seems to be focused entirely on NMGC.
And in formulating your opinion, did you consider that, quote, Emera's decision to pursue a potential sale of the company is also driven by geographic considerations, with emphasis on geographic considerations being in that document?
Yes, I see that appears to be a factor that they are considering in their decision on whether to sell NMGC. It certainly isn't the only one, though.
That wasn't affected by a sale or absence of a sale of Labrador, correct?
No, no, New Mexico would remain in its place.
But you did not incorporate that into the opinion in your testimony, correct?
It seemed to me that, based on my analysis, that Emera's primary concern was that the financial terms of the sale would be neutral or positive. And so that was where my focus was, rather than these other considerations.
And that impact would be inclusive of what is set forth on the right side of this page. Quote, our priority was strengthening the financial position of the company based on the increase in the cost of capital we've seen over the last year. The continued deleveraging and strengthening our balance sheet is even more important.
This is why you will see that select asset sales now form part of our capital investment funding plan. Correct.
Objection. So the question is ambiguous and is referring to impact, and I don't think it's clear to the witness what impact specifically the council is referring to.
Mr. Dubois?
I'm not sure on what basis Ms. Beatles can describe whether Mr. Cebulko is confused by the question or not. He may be now,
Well,
but I'm not sure that she can.
he answered the question.
I said maybe.
So the objection came in after he answered the question. You said this is why you will see asset tails more form our capital investment funding plan? Answer, correct. Then the objection came in. So
I'm not,
there's nothing for me to rule on. The witness answered the question. So you can go on to your next question, Mr. Dubois.
Thank you, Your Honor. We could please go back to your testimony. We're back to page 15 again.
I'm there.
And on line 17 to 18, you indicate that an NMGC under BCP applicant ownership would have a strong incentive to cut operating costs, correct?
Objection. It mischaracterizes Mr. Cebulko's testimony. I believe it's stated in the alternative.
Mr. Dubois?
I'm not sure what any alternative means in that context. Perhaps I am misunderstanding, and Mr. Cebulko can just explain what he means by that then.
Well, you want to rephrase your question?
I'll give it a shot, Your Honor.
Very well, thank you.
Mr. Cebulko, who are you saying will have a strong incentive to cut operating costs, and under what conditions?
I did not say here. I said that this is those are one of three ways that the utility, I apologize, Mr. Lee. The context is that I identify that after the premium acquisition, the investors into the infrastructure fund are going to want to earn a reasonable rate of return. My expectation would be along industry norms. What I identify here is after the premium acquisition, essentially say that they're operating from a whole, which is the premium acquisition. That's real money they're putting out there. And to achieve returns that are commensurate with industry norms, but to do so in a 12 to 15 year period is going to require some combination of either cutting operating costs, seeking an increase, a change to its cost of capital, or accelerate growth of rate base. That's what I testify here.
You didn't answer the question, Mr. Cebulko. Your testimony at line 17 says to generate a reasonable return, they will have strong incentives, and then you go on to name three things. The question was, who is the they that you're referring to in that sentence.
Thank you, hearing examiner. It refers to New Mexico Gas Company as well as the upstream parent companies, which are the owners of New Mexico Gas Company.
And to go to your metaphor of the acquisition premium constituting a hole that a utility owner is trying to dig out of, isn't it correct that Emera and NMGC, under Emera's ownership of NMGC, has had a much deeper hole than any that would be associated with this transaction?
Perhaps, but that doesn't mean that it's not relevant here as well.
Perhaps, but you don't know?
No, I'm saying here that this is a problem. Perhaps it was an issue with Emera as well, but they could be selling for a whole variety of reasons. I have not done the calculation to see, if the dividends have been over time have more than made up for their expected revenues. What I'm acknowledging here is that investors are outlaying real money that they will hope to, that if they're doing so, they will want a reasonable return on their investment. And so there are only limited ways that they can earn a return, and I've identified them. And then I explain in my testimony the issues with each.
Mr. Cebulko, are you aware of any harms that have come to NMGC customers as a result of the duration of the hold periods under prior ownership of NMGC?
There is a real transaction cost associated with changing ownership.
I'm sorry, there is a
real transaction cost associated with changing of ownership. Uncertainty about the future would be one. Uncertainty about changing customer service, investments. So I would say that those are considerations every time a utility changes hands.
So it's a consideration every time, but it is not actually manifested as a harm to your knowledge, correct?
To the extent that I've quantified that, no.
Your Honor, if I stop here, could I bank 10 minutes to transfer over for Dr. Blank, please?
Well, we haven't had that question. If people don't use the time, can I move it?
Can I move?
Yeah.
I think I have a little bit more than 10 minutes. Could I move 10 minutes to Dr. Blank and stop here, please?
We keep moving it the other direction. Any objection to moving the 13 minutes that he has to be 10 minutes to Dr. Blank? I think that's fine. I don't hear anybody complaining, Mr. Dubois. So, okay.
Thank you, Your Honor.
So you're finished.
I am finished then. Thank you.
Okay, very well. I do not see that we had any other time reserved for cross-examination. I do have a few questions for you, Mr. Sabuco. Um, again, welcome. And I think you indicated that you were familiar with the record in this case. So I specifically wanted to ask you whether or not you had the opportunity to review the staff's testimony, the New Mexico PRC staff's testimony in this case.
I reviewed a little bit of Dr. Blank's, and I skimmed one or two others, but I cannot say that I have as much familiarity as I would with the applicants or my own.
Okay. Have you had the opportunity to review the bench requests, responses that have been filed by the joint applicants, and specifically bench request 1 began at the beginning of the hearing, and that was a bench request to joint applicants to provide a list of commitments that they had agreed to in their rebuttal testimony, and then that weren't already apparent in the direct testimony. Did you have a chance to see those?
I did, and I have it in front of me as well.
Okay. And then they just filed this morning the joint applicant's response to the third bench request, which basically was an attempt to pick up anything that they agreed to during the course of these days of hearings. Did you have a chance to see that?
Unfortunately not, but I am opening it at this moment.
Okay. So just I'll begin with the first one and just ask you, and I mean, if you had the opportunity also to look at the joint applicant's response to the second bench request, which was basically for them to identify any records regarding how gas company board currently operates. But I kind of want to ask you about the commitments in relationship to either your testimony or the staff testimony. And staff witness Zigich is what we used to refer to as the case coordinator, because he basically introduces the other witnesses, and then he is giving summary of staff's position. Did you have a chance to look at his testimony?
No, I have not.
Well, was it generally your understanding in the testimony that you looked at that staff has a recommendation in the alternative that lays out some specific additional commitments, and if these commitments got approved, then staff would recommend approval of the transaction? Is that your understanding?
As you characterized it, I would trust that you're
Yeah.
conveying it correctly.
Okay. So, when I'm referring to page 16 of Mr. Zigich's testimony, the question posed at line 4, what is staff's final position to the acquisition transaction proposed in this case? Answer begins on line 5 and continues through line 9. After completing a thorough review of the case record, comma, PRC staff have developed the combined staff positions presented in table 1.
PRC
which
staff
is
have developed.
the combined staff positions presented above in table 1, and that's located on pages 5 and 6, comma, regarding the 6 factors recognized by the commission, period. Based on those positions, comma, which assume the joint applicants substantially accept staff's recommended additional commitments in table 2, located on page 8, staff recommend approval of the transaction. So that kind of looks like, doesn't it, Mr. Sabuco, that if joint applicants agree to the things on table 8, then staff's going to recommend the transaction, right?
I'm hearing there. I apologize. The staff exhibit 1 that I have in front of me. I did not find that page 16 with that table. And so I'm wondering if I'm looking at the correct.
You need to look at Mr. Zigich's testimony. Mr. Friedman, you want me to give me your exhibit number on that?
Madam Hearing Examiner, this is Nick Rossi. It is Staff Exhibit 1. The table you're referring to is page 8.
Thank you.
Thank you.
Actually, the first was table 1. That's on page 5 of what I have. It's summarizing the proceeding. So that was table 1. And then they have a table 2 that's on page 8. And then I was just reading from page 16 what staff's final position. So again, at line 7, no, line 8, staff's recommended additional commitments in table 2. Staff recommend approval of the transaction. So are you there on page 8?
I am. Thank you for your patience.
Sure. Let's look at factor 3. Commit to maintain pipeline operations and safety staffing levels for 5 years. Maintain capital investments consistent with current.
I'm sorry, maintain, Judge, I have lost a bit of my speaker, so if you could speak louder. And number 2, maintain.
Maintain capital investments consistent with current NMGC 5-year plan and maintain progress on digitization of infrastructure records. You see that factor?
Yes.
Did you happen to see in the answer to the bench request, the first one on item 4, that the joint applicants committed to maintaining the 5-year capital investment plan?
I did.
And then factor 6 talks about regulatory asset.
Yes, I see that as well.
And then if you looked at item 6 of bench request 1 on bottom of page 4 about booking a regulatory asset and then withdrawing that request. Do you see that?
I see that now, yes.
So it kind of looks like that, at least with an overview here, we'll find out more when we talk to staff, but it looks like 2 of the 3 factors are in the first bench request, aren't they?
That is staff's recommended additional commitment factor 3 on the 5-year CapEx investment plan.
Right.
I don't necessarily agree with that recommendation.
Right, and I haven't gotten there yet. I'm
Okay.
just trying to I'm just trying to make sure that you understand where I'm coming from.
I'm following you,
Okay.
yes.
Okay. So based on staff's recommendation, it looks like at least 2 of these 3 additional recommended commitments have been agreed to, doesn't it? Staff's additional commitments.
That's correct.
So now we get to the question you wanted to answer. Okay. I know how you experts are. It's not the question I ask, it's the question you wanted me to ask you. So now here it is. Since staff appears to be the only party in this case, other intervener slash staff party, who is even mentioning that they would entertain recommending to the commission that the transaction be approved. What's your response to the staff recommendation?
Appreciate. It looks like we are aligned on the treatment of the regulatory asset, so I want to deal with that one first. And appreciate the joint applicant's request to withdraw. With respect to factor 3, the commitment, I'm fairly comfortable with the commitment to maintain pipeline operations and safety staffing levels for 5 years.
Just wait 1 second. Did you say fairly or barely?
I think it's fair. Like I am fairly fairly comfortable. FAIRLY.
Okay.
Comfortable with that to maintain pipeline operations and safety staffing level for 5 years. That doesn't strike me. That strikes me as a reasonable request, in line with public interest of maintaining safety and reliability. I disagree with staff on the 5-year CapEx plan, and it's primarily because I have not seen either in this record or anywhere else where the commission has reviewed the prudency of the 5-year capital expenditure plan, or even what is in it. And that was something that stuck out to me during this case, was that the BCP applicants seem to grab that concept from Amera and say, okay, we commit to this too. And my reaction is, does that in any way reflect actual needs? You know, a historic 5-year in the case of that BCP applicant's testimony, but even the current 5-year plan, does that necessarily, it seems to imply that all that CapEx is prudent and reasonable. And I can't say that with any certainty. And so I would not go so far as staff did in this recommendation.
Did you hear Mr. Shell's testimony when he was questioned on how gas company currently uses that 5-year? Because it's, if I recall his testimony correctly, it sounds like it's always almost like a 5-year on a going forward basis. It always rolls on the next year. And that is how gas company plans its capital and replacement going forward.
Yeah, that would be, unfortunately, I did not hear Mr. Shell's testimony, but your description where the company is developing a 5-year CapEx plan annually, that would be consistent with other utility planning practices. And that does not surprise me at all. I guess when I read factor 3, what staff has put here, it to me read maintain capital investments consistent with the current 5-year plan. So that seems static to me, like maintain the plan that's available today for the next 5 years. And so that's how I interpret that. But perhaps staff could clarify. Or if it has, I have not seen it.
With at least with your understanding of the additional commitments in the first bench request and those specifically that you've just looked at that were important to PRC staff, are any of your concerns eliminated that you've testified about?
Well, I believe the reg asset that they're walking back, the reg asset associated with the IT services. And so that I find that to be beneficial. Although it doesn't, I still have my concerns relative to their estimates and the commission relying on their estimates and stated benefits to justify this acquisition. And I also want to note the constructive and helpful movement from the joint applicants, particularly with respect for additional funding for low-income customers, entry-level training. I think that's good movement. What I haven't really seen here is a satisfaction of my structural concern, right? Which was that essentially the company is forecasting flat sales, more or less. It's slightly increasing volumetrically as a whole, but that's primarily—
Sorry, it's slightly increasing.
That sales are more or less flat. They are slightly increasing, primarily driven by large customers. However, those large customers typically take service, I can't say with certainty, at New Mexico Gas Company on the transmission system. Residential customers, the vast majority of the customers, their annual demand is declining. And the mayor, as I point out in my testimony, talks about the long-term risk to annual demand. And what I've seen is a lot of capital expenditure growth in the recent past and a forecast of it continue in acceleration. And the annual demand is either flat or slightly declining. And that puts real affordability pressure. And the BCP applicants are not going to be here for very long. 12 years, 15 years at the max. And those investments that they're making are going to be there 30, 50, 60 years. And customers will be there the whole time too. And so there's a lot of risk being put on customers. And that is the primary concern I've discussed in this testimony. I'm just not seeing that satisfied in the commitments.
Well, having worked at the Washington Commission and having had to deal with rate cases and having looked at especially the safety aspect of when a public utility comes in and says, hey, in order to make sure that there's safe, reliable service, we've got to replace this, and this. I mean, those are pretty serious issues that commissions have to deal with, aren't they?
Absolutely. Safety is paramount. It's first and foremost.
And so having heard gas companies' last few rate cases, I can tell you that when they come in and they talk about and present, they don't just talk about it, but they present evidence on what things need to be replaced, the commission takes it very seriously. And so you're not suggesting, are you, Mr. Sabuco, that the commission discourage capital investment because there might be flat demand, are you?
Absolutely not. That's not no, that's not what I was saying. And my testimony does decidedly say that absolutely need to continue making investment to ensure the safety and the reliability of the system. What I'm talking about is the commission will do its review of the utilities proposals in its rate case, but that we have to acknowledge the structural incentives that we're talking about here, and the challenge that leads, and what gets put into a rate case. And we have to also recognize that the utility could spend unlimited amounts of money improving the safety, but that is not a reasonable thing. We have to also be conscious of affordability. And those two things is the tension of a commission, right? To balance what is safe, reliable, and affordable. And the conditions of this acquisition make me concerned that there's likely to be over investment. And yes, the commission has an opportunity to review those capital expenditures, but disallowances are not great for anyone. It's certainly not great for the utility. It's not even great to customers. It harms the utility's credit rating. It does not. We want a financially sound and healthy company. And so we want to avoid those instances and avoid those outcomes.
Oh, I don't know if you were listening to the testimony of Mr. Waters, who was a couple of witnesses ahead of you.
It did.
But he also seemed to be focusing on the number of times so far that gas company has been sold. And you referenced that in your testimony. So I'm going to ask you the same question. It's like, if whoever owns the company wants to sell the company, and whoever wants to buy the company is looking for a company, which the record in this case has indicated through the testimony of several witnesses, is a well-run company, whose ratepayers, at least the ones the commission has heard from, are generally happy with it. And based on the financials that, or at least some of the financials that they have presented, gas company is paying dividends. Then who wouldn't want to buy this company?
I can't answer that. Who wouldn't want to answer it? I think the conditions you described goes to show that people are happy with Amera's ownership, and Amera's stewardship at this time. And I did talk about in my testimony that these transactions are administratively burdensome for us, but they're also challenging for the employees of the company, the uncertainty that creates, as well as to the customers. And to your question about who wouldn't want to bid, I think that was explored, and I don't remember what exactly is confidential, so I don't want to get into it, but it wasn't a. I'll stop there because I just don't recall what's
Okay.
not. But
Well,
yeah.
Let me put it this way. Do you know, on the basis of your regulatory experience at the state level, not being a lawyer, do you know of any regulatory precedent or standard that commissions use to make a company that wants to sell keep ownership of the company?
Yes. Yes,
And
I was.
what are those?
Yeah, I was an advisor to the Washington Utility Commissioners when they considered Hydro One's acquisition of Avista Utilities in Washington State, and the commission rejected that acquisition. And Avista continues to be under its same ownership. I think it's a publicly traded company since that, and that was 2018, 19 time frame. And so yes, and they continue to be a well-run company under its same structure after the rejection of the acquisition.
Did your analysis consider if the commission does, if the commission would not approve this acquisition, what risk that gas company or its customers might face going forward?
Those risks are unknown. The risk of the BCP's applicants, their proposal, are known, right? I could evaluate that, and then I have to compare, well, to what? To continue the ownership of a company that it seems would desire to sell NMGC, but I believe, as stated, did not see it as absolutely necessary. It's perhaps not the worst thing for Amera to end up with a company that we continuously hear is well run and paying dividends. And the commission does not have to approve every acquisition that comes before it. It is charged with ensuring that the proposal is in the public interest. And Amera will have to continue to provide safe, reliable, affordable service for its customers because that's the regulatory compact that it entered into.
But couldn't the same things that you talked with Mr. Dubois about on page 15, about generating a reasonable return, couldn't, if gas company wants to sell, I mean, if you put it in the context of this case, if Amera wants to sell gas company and they know they're going to take, since because of the impairment, they know they're going to lose money on the take a loss on the acquisition adjustment, goodwill, premium. Couldn't they start cutting costs, reduce employees, seek an increased return, on equity or more favorable capital structure, and try to come in and increase rates?
You're saying, yeah, to the extent you're saying that the incentives I've identified should apply to Mara as well, and they could start acting in that manner. So
I'm
that's how
not saying they should. I'm asking you, it's your testimony.
yeah. Well,
Yes.
we'd have to look at, I have not looked at the utility, Emera's, the prudency of all their investments recently, but I did know the accelerated growth, and that's concerning. And I identified the inherent capital expenditure bias to any owner. And so that would apply to whoever buys MMGC. But my understanding is that this commission, and as you describe it, the customers seem relatively happy under Emera's stewardship, and the commission would have to continue to keep a close eye on any of these things happening. But I think what's really catching me is just the position the BC applicants are putting their investors in with this close-ended term, right, of 12 to 15 years, 10 at a minimum. Recall, like initially it was just 5 years, and where they have to. I just don't. You can't just. I can't imagine being an investor and just saying I don't care about the premium acquisition, 130, 185 million, whatever it was, it's gone, right? Like that was part of the investment, and so they will want to seek to earn a fair return. It seems that Mara's selling seemed to be in part strategic. I don't see a similar strategic focus for the BCP applicants, other than, a financial play here. And absolutely, an owner is entitled to a fair return. It's just the conditions being put forth, I think, are risky for customers.
I appreciate your time, sir.
Thank you.
Ms. Beatles, any redirect for Mr. Sabuco?
Yes, I have one question.
Go ahead.
The hearing examiner was asking you about the 5-year capital investment commitment and its significance or value. And in response, you mentioned that disallowance is not great for utilities or customers. Is that correct?
Yes.
So what are the alternatives to disallowance?
I would focus on planning, prudent planning, and having a transparent review of the utilities capital and operational expenditure plans going out. And I recommend in my testimony for those costs to be examined within the integrated resource plan to shed light beforehand, on those investments, to give staff, interveners, the commission an opportunity to review those investments before they're made.
That's all I
Ms.
have.
Beatles.
That's all I have, Madam
Thank
Hearing
you.
Examiner. Thank you.
Thank you, Ms. Beatles. Mr. Domi, any recross based on my questions or Ms. Beatles' one question?
No, ma'am, I do
Sure.
not have.
Thank you. Mr. Dubois, any recross?
Briefly, Your Honor, please.
Go ahead.
Mr. Cebulko, please correct me if I'm wrong, but did I understand you to say in your discussion with hearing examiner Hurst that your interpretation of the public comment was that Emera has operated an MGC well?
You're asking if I Yes, that's my understanding based on the hearing examiner's characterization of public comment.
And where did you identify that Emera has been operating NMGC's operations?
I don't believe I said that.
Do you believe they have?
Do I believe that Emera makes operational decisions for NMGC?
Yes.
No, not.
Thank you. That's all, Your Honor.
Thank you, and I didn't mean if I misspoke if I had indicated Emera, I meant Emera as the owner of New Mexico Gas Company operating. But I understand why you need to make the clarification, Mr. Dubois, in distinction. Mr. Spuko, thank you very much. Appreciate your
you.
time and your excuse, sir.
Thank you. Have a good evening.
You too. I believe, due to the lateness of the hour, we will not have any further witnesses today. My understanding is per agreement, we will begin tomorrow at 9 with Dr. Zadelis. Then we'll come back, I believe, Ms. Beatles, to you for your other witness. And then we will continue with the rest of our intervener witnesses. And I don't have the list for the exact order, but it's what we agreed to. Is there any other witness that we need to consider time limitations other than Dr. Zadelis tomorrow? Ms. Lynch.
Yes, I apologize for my misunderstanding. Dr. Stephanie Penn is available tomorrow until 10:30 a.m. and then she'd be free again on Friday.
Okay, well, we've got two people that want 9 o'clock, so I don't know what to do.
Madam Hearing Examiner, Mr. Kenny is available at any time tomorrow.
Okay. But I don't know if potentially, you said 10:30?
Yeah, she's available until 10:30 and then anytime on Friday.
Okay, well, we've only got, I don't know, it's gonna be too close, I think, Ms. Lynch. If we're allowing Dr. Zadelis because of his childcare responsibilities to come in at 9, then we won't get to Dr. Penn until Friday morning. But we
Okay,
could go
and
ahead.
I mean, go ahead.
We could go ahead and take her out of order and go ahead and have the staff witnesses go if we complete your other witnesses, Mr. Kenny and the FEA witness.
Okay, and all of our witnesses can also be available on Friday if we want to take all of them out of order.
Okay. Let's stick with our order right now and there, you know, you can let Dr. Penn know that there's potential that we could get to her, but it would be off. I'm afraid that time's gonna be too close. So you might just advise her to be available Friday morning.
Okay, I'll do that.
Okay.
Thank you.
Okay, let me just, here, I found my sheet. Yeah, so it was Mr. Waters, Mr. George, Mr. Sabukel, then it's gonna be Mr. Kenny, Ms. Petuli, Dr. or Mr. Price, Dr. Penn. Okay,
Madam Hearing
might be
Examiner,
reading
does
till
Mr.
Friday.
Kenny start tomorrow, or is it the staff witness?
No, well, no, it's staff asked for an accommodation of 9 o'clock because Dr. Zadelis has a sick child and childcare responsibilities are covered if we can have them at 9. So I didn't hear anybody object when that was mentioned. So Dr. Zadelis is going to be tomorrow morning at 9, and then we go to Mr. Kenny.
Yeah, I'm absolutely fine with that. I just wanted to, there's a little delay in
Okay.
the audio between your lips moving and the sound on my end, so I just needed to click confirm. That's all. I'm sorry.
Okay. No, not at all. Okay. And then we might have to take Dr. Penn Friday morning. And those are the only two that I know of. Okay, very briefly, with regard, is anybody going to object to the introduction of bench request 3, which was filed this morning, which were the additional commitments made during the hearing? Hearing no objection, I am going to admit bench request response. Let me rename it. I am going to admit bench request 3, joint applicants response to the third bench request filed today. The other thing that I want to mention, so the parties can be working on this, is Ms. Nanasi has made 2, as indicated, she's going to make 2 offers of proof, and I believe Mr. Yar also indicated he was going to make an offer of proof, and this is pursuant to Commission Rule of Procedure 1.2.2.35M. And that rule states offers of proof, an offer of proof for the record may be made and shall consist of a statement of the substance of the evidence to which objection has been sustained. The commission or presiding officer may require offers of proof be submitted in writing in question and answer form. Therefore, pursuant to the request of Ms. Nanasi and Mr. Yar, your offers of proof shall be submitted in question and answer form. Okay. And I have a joint applicant hand, Mr. Dome.
Yes, Madam Hearing Examiner, at the risk of speaking out of turn and too late, it seems to me, it just may be my computer, but your voice, something about after the break, you were not coming through nearly as clearly and as resonantly as you did before. Something about your microphone changed at the break, and I just mentioned it to you because I noticed the difference, and I'm not sure if I'm the only one.
You're not. I also noticed it.
Yeah.
You are not.
Does that mean I should stay home tomorrow?
You sound like you're in the bottom of a barrel after the break, Pam, to be frank. It's not nearly as clear as it was.
Okay, I'll look into that with IT before the hearing begins tomorrow. Thanks for pointing that out. I appreciate it. Mr. Lee and, Ms. Nanasi. Thank
you,
everybody
Madam.
for staying later. Yes, ma'am.
Thank you, Madam Hearing Examiner. I just wanted to remind you that I have another hearing tomorrow morning, so I won't be here. And then also I look forward to whatever your decision is around how I should change the Christopher Sandberg testimony. I just want to also say that since it was a new exhibit, the first time I put it in new energy economy exhibit 2, which you accepted, if I redlined it, which I did, but the first one that I put in didn't have a label. So please use the second one. So that it just didn't have that label, New Energy Economy Exhibit 2. Because as I was making
Okay.
a new one, I forgot to do it. So please use the latest one.
Okay. And, you know, with regard to, and I'll still think about it, but with regard to the Sandberg exhibit, I mean, it seems like what I indicated to Mr. Yar, about Mr. Waters' testimony, about just striking out the reference to the exhibit, where, you know, see attached, whatever, if that's what the testimony says. If you just put you know, a note at the beginning that says, you know, references to 5, 6, 7, uh, uh, you know, should, you know, were those exhibits were not admitted, um, and then just strike, you know, that seems like the cleanest way. But again, if somebody wants to recommend to me a better way, I'll listen.
Okay, the only question I have about that is there are some things that are in the middle. So like, I think you accepted, I have to look at my list, but like 8, but then you didn't, the next couple of them, and then 19, 20, and 21 were accepted. So, but I should just keep that as exhibit 19, 20, and 21 and not go back and try to numerically change. Is that right? That's what I
Yes.
removed. Okay, and then I will just remove the exhibits that you've struck.
Yes.
Okay, thank you.
But that, I think that seems clear. You know, I'll also talk with Mr. Lee, and get his guidance, on trying to have the most clear record we can. All right.
Yes.
Okay. All right. Thank you all very much. Thank you, Mr. Lee, for staying with us. And thank you, participants, for all staying late tonight. I'm feeling good that we're on the path. I think that we are going to be able to have adequate time to present all of our witnesses, and so I thank you all for your efforts and wish you a good night. And we are recessed until 9 o'clock tomorrow morning. And I will check on the audio. Thank you.